Morning, Justices. I appear for the first and second applicants in the confirmation proceedings. We call them the embrace applicants, together with my learned friends Ms. Pasha, Mr. Winks, and Mr. Mirzayev.
Thank you, Ms. Rajab Patlinda.
Good morning, Justices. I appear for the applicant in the Leave to Appeal application, the Center for Applied Legal Studies, with my learned colleague, Dr. Swema.
Thank you, Ms. Mahorane.
Good morning, Justices. I appear on behalf of the state parties, together with my junior advocate, Makamu. I am Poswale Rotodi. Thank you.
Thanks, Ms. Poswale Rotoli. Perhaps if you could help us with your, you were quite inaudible, but later on during your address, if you could try and raise your voice. Thank you.
Good morning, Justices. I am Tamika Thambiran, and I appear on behalf of the first and second Amicus Curiae, the Center for Human Rights, and the Psychological Society of South Africa. I appear together with my learned friend, Ms. Ruth Kruger, and we are instructed on behalf of Lawyers for Human Rights.
Tumbarani.
May it please you, Justice Mshlanshla, Justices of the Court. I appear together with my learned colleague, Ms. Pithy, from the Women's Legal Center for the third Amicus Curiae.
Thank you, Justice Mhlantla, Justices of the Court. This case, at its core, is about how the law treats victims and survivors of sexual violence, and whether, as it presently stands, it does enough to protect them in the context of their constitutionally enshrined rights. And if not, how best we are to cure that and correct that unconstitutionality. So in these proceedings, the embrace applicants seek confirmation of the judgment of the High Court, which found sections 3, 4, 5, 6, 7, 8, 9, and 11A of the Sexual Offences Amendment Act unconstitutional. We ask for confirmation of that order. We also ask for a suspension of the finding of infidelity for a period of 18 months, and we propose an interim reading in during the period of suspension to be made final in the event that Parliament doesn't amend the statute in the suspension period. The provisions that we challenge were identified because they are offences which have as their elements or elements of the crime consent and intention, and they therefore, we say, trigger the question of whether subjectively the accused was aware that the victim did not consent. All of these offences involve an attack on the most intimate, private aspects of a person's life, their body, their sense of autonomy and power. And most importantly, it has a direct and important effect on their dignity. Now, in the course of today, it would be very easy for us to become focused on what from the papers appears to be complex legal arguments around legal terminology, around what's the most appropriate and constitutionally compliant construction of the statute that is before this court. And while those things are absolutely issues that this court has to engage with, I would like to draw the court's attention to what lies at the heart of why we are here today. And that is the very traumatic and life-altering experience of our client, Miss Holtztrager. She's the second applicant in the case. The first and second applicants, the embrace applicants, are the only parties that come before this court with a complainant who has experienced firsthand the way in which our courts understand the statute and implement it. And she has told this court in our founding papers in the High Court in her supporting affidavit that her experience of the law, as it stands, is that it has failed her. And this was not simply her understanding of the law, this was also the understanding of the magistrate that presided in her rape trial. And that is because the magistrate made it patently clear in her ruling, and I quote, "In our law and the reported case law that I'm bound to follow, the belief that a woman consents to sexual intercourse need not be a reasonable one, as the test to establish intent is a purely subjective one. The fact that the complainant did not signify her opposition to the acts in any way makes it impossible for the court to be satisfied that the accused subjectively knew that he did not have to consent to proceed with the acts. Furthermore, the state must prove the lack of consent beyond reasonable doubt, and the court cannot, as the law stands today, say that the state has proved this." End quote. So that is why we're here today. And while there are very many intellectually very interesting arguments raised by the many parties before this court, we simply wish to remind this court of Miss Holtztrager's personal experience and the fact that she's before this court to try and fix what happened to her. The burden that the state has to meet through the provisions as they currently stand is almost impossible, particularly in circumstances where a victim has what the Amicus refers to as a peritraumatic response, which can incapacitate a victim and, in the case of Miss Holtztrager, cause them to freeze, or in her words, feel like she was in a trance. In my address today, I will refer most often to the crime of rape. That's because that was the experience and that those were the charges in Miss Holtztrager's case. And certainly Section 3 of the Act, which deals with rape, is challenged by us. But when I do so, I just wish to make the point that my argument applies with equal force to all of the other impugned sections, all the other offences and the provisions that we challenge. Now, in my address, I intend to cover the following issues. First, I'm going to deal with some contextual analysis of sexual offences in South Africa. I'm then going to move on to, very briefly, the facts of Ms. Holtztrager's case. Next, I'll turn to the rights violations and why we say these particular rights have been infringed by the impugned provisions. And then I'll next look at why these violations are unjustifiable through an evaluation of the minister's case, and also the case for the WLC, which overlap to some extent. Finally, I'll look briefly at Kels's case and say why we think that the relief sought by the Embrace applicant is the more appropriate relief for this court to adopt. And in doing so, I will end off my submissions by looking at the specific relief we ask for. I don't intend to deal with international and comparative law in my 30-minute address, just because of time, but I point the court to the fact that they dealt with it page 24 of our heads, and if there are particular questions from the court, we will deal with it at that point. Now, to begin with my first topic, which is intended to give some context. Rape, we know, because this court has many times said so, is an attack not just on the body of a person, but on the dignity of a human being. It's an invasion of their very being. And this court has been, in many ways, more advanced than courts around the world in indicating on several occasions its appreciation of the very extreme and degrading nature of rape. And it has also repeatedly recognized the pervasive nature of sexual violence in South Africa and the very gendered nature of that violence. There are many cases, and they're all in our heads. I refer the court to AK versus the Minister, Carmichael, Masia, Chabalala, and Ntuli. In S versus Chabalala and S versus Ntuli, this court said that rape threatens to destroy both the moral and social fabric of society. And I would submit that that is not an extreme statement, it is true. We know that South Africa has one of the highest levels of gender-based violence in the world. This court has referred to the fact that sexual violence in South Africa is a scourge. Our courts, our academic writers, such as the P.J. Schwickard, who we refer to in our academic bundle, have also recognized another issue that feeds sexual violence and that reinforces the act as it currently stands. And that is what we call rape myths. We deal with this in our heads of argument at page 15. But it is important for this court, as part of understanding the context in which the act is interpreted, to take into account these stereotypes and rape myths. And these are things For example, like the notion that unless a woman screams or fights or tries to run away, that she must be consenting to the act. Or that, as this court has referred to, it's always the monster who rapes, not the father, not the brother, not the uncle. That's another myth. Or if that you consent to one act, that you're effectively consenting to a whole series of acts. And while the law has tried to keep up with these things, and certainly the Act has been amended in an attempt to deal with, societal norms are much harder to change, we know that. And these feed sexual violence, and when they find their way into the subjective intention and subjective the mindset of a rapist, in the context of this statute as it stands, it makes it virtually impossible for the state to prove beyond a reasonable doubt that the accused subjectively knew that the victim did not consent. So in the context in which this act is implemented by our courts, that context is closely connected to the unconstitutionality. This court has said something to that effect in Prinsloo versus van der Linde in the context of an equality challenge. And that's at paragraph 20 of Prinsloo versus van der Linde. The effect of all of this is that it results in very low conviction rates for sexual violence, and it results in a further undermining of victims' rights. In the papers put up by the Psychological Society of South Africa, the Amicus in the High Court, they recorded, and I'm afraid they're not in this bundle, but if the court would like reference to that, we will find it and make it available. But those stats were particularly helpful, and I quoted them in the High Court. In South Africa, between 2022 and 2023, 42,780 cases of rape were reported. 42,780. Of these, there were only 591 convictions. This translates to a 1.38% successful prosecution rate. 1.38%. Something is clearly wrong. And we submit that there are many factors for what's wrong, but in large part, that has to do with the difficulty of proving these crimes, the burden that is on the state. And that is the subjective standard we submit of consent that is inherent in Section 3 and the other impugned sections of the Act. So that is the broad context in which our argument must be seen and in which the constitutionality of the statute is challenged. If I can then turn to Ms. Holtztrager's experience. The facts of the case are detailed in the supporting affidavit of Ms. Holtztrager in the High Court and in the magistrate's ruling. That's at volume 2, page 196 of the papers. The facts are graphic, and I do not intend to repeat them unless necessary or asked to by the court. But for what's necessary for this court's purposes is this. Ms. Holtztrager was 20 years old when she was raped in 2018. She was raped by a man that she met through an online dating application. He invited her to a party at his residential estate in Pretoria. Her mother dropped her off. And once she arrived at his home in the estate, she realized that there were no other guests present and that there was clearly no party. In evidence in the magistrate's court, the accused could provide no credible answer to why he had invited her to a party that did not exist. He gave Ms. Holtztrager a brandy and coke, which she said tasted strong. They sat on the couch and they talked. At some stage, soon thereafter, the accused started kissing her. She did not object to that, and she returned his kiss. But then things moved very quickly to the accused removing her clothes and raping her. Importantly, Ms. Holtztrager says she was shell-shocked and she was in a trance and she had an out-of-body experience. Her evidence was, in the Maj Court, that she said no, but that she was not sure whether he had heard her say that. She admitted that. His version was that he had heard her say a word, but that it was not stop. After the trial, which was traumatic for Ms. Holtztrager, but which canvassed all of the relevant evidence, the accused was acquitted in February 2019. In its reasoning, the magistrate's court found that Ms. Holtztrager had objectively not consented to the sexual acts, but because she had neither physically resisted or loudly protested, the state had not been able to exclude the possibility that the accused did not hear her say no, and thus had not been able to prove beyond a reasonable doubt that he knew or foresaw that she was consenting. The magistrate's court judgment is hard to read because the frustration of the magistrate is clear from the pages of that judgment. But the magistrate makes very clear that her hands were tied, that the law required an assessment of the subjective mindset of the accused and whether subjectively he knew that she consented, and that in the absence of any objective facts to prove that he did not subjectively know that she consented, there was nothing that the court could do. The magistrate also says very specifically she thinks the act is unconstitutional. Now, of course, that has no bearing on this court, but it gives you context to how the act was interpreted. Importantly, for when we analyze the WLC's argument, the magistrate specifically considered whether Dolus eventualis was applicable in this case and found that it was not because there were no objective facts and because the subjective element of Dolus eventualis was insurmountable. We'll come back to Dolus eventualis in due course, but I'd like to, just in light of my time constraints, move on to the next topic, which is the rights infringement. We have asserted in our papers that the impugned provisions infringe equality, dignity, privacy, bodily and psychological integrity, and freedom and security of the person. In the case of rape specifically, this court has said on several occasions that rape constitutes a brutal invasion of privacy, dignity, and the personhood of the victim. And that's in Chabalala versus S and in Tuli versus S most prominently. In Vilakazi in the SCA, all of these cases, by the way, are referred to in our heads. In the SCA, Judge Nugent referred to one of the arguments made by the parties, endorsed it, and said that a woman's right to give or withhold consent to sex is one of the most commonly violated human rights in South Africa. So we would submit in the context of rape, in the context of Section 3, the Act clearly infringes the dignity, bodily integrity, and freedom and security of the person. And most often, the person whose rights are infringed in this respect is a woman. We also make an equality argument, but we do so knowing that this court has yet to find that in the context of rape, that, unless I'm wrong in my reading of the jurisprudence, that equality is infringed. We make the argument and we ask the court to consider the argument. It requires a nuanced evaluation of the gendered nature of sexual offenses and of the implementation of the subject standard and how it affects women disproportionately to men in South Africa. We say it then results in it has a discriminatory effect and infringes equality. The starting point of the equality analysis has to be, we submit international law under CEDAW, which we deal with extensively in our heads, which provides in its general recommendations that state parties must repeal provisions that allow, tolerate, or condone forms of gender-based violence against women. You'll find that at page 29 of our heads, paragraph 74.3. And in our founding affidavit, volume 1, page 35, paragraph 16 to 19, we deal with this more extensively. But the point is that in interpreting the right to equality in the context of gender, CEDAW requires, international law requires South Africa to take steps to repeal legislation which allows gender-based discrimination. But even if you move below that, but to our domestic law, our courts have said repeatedly, in Carmichael, for example, our courts have said sexual violence and the threat of sexual violence goes to the core of a woman's subordination in society. It's the single greatest threat to self-determination of a woman. That's at paragraph 62 of Carmichael. When one considers that rape and sexual offenses affect women disproportionately to men in South Africa, when one considers the difficulty with which the law permits, well, the difficulty of conviction, which are borne out by the stats that I referred to, we submit that there is a case to be made that women are denied the equal protection and benefit of the law, and that the law as it currently stands discriminates against them unfairly. But we also say that if this court does not want to engage in the equality analysis, it doesn't have to, because very clearly dignity, privacy, and bodily integrity are infringed by all of the impugned provisions. it is absolutely clear that these provisions go to the absolute heart and the most private spaces of a person's personhood, and affect their dignity, their privacy, and their bodily integrities in ways that are difficult to imagine other offences doing. Although I've talked again extensively about rape, all of those other sexual offences we submit should be dealt with similarly, which is because they have as their core element intention and consent, and because the effect of that particular crime is so degrading, so humiliating, we submit that they would then infringe the rights to dignity, privacy, and bodily integrity of the victim. There are a few other highlights that I want to simply just mention that relate to the effect of the statute, and they're these. It's tried by now, and you'll see it extensively in the Amicus submission, that many victims, many survivors of sexual violence do not fight or flee, but they freeze. That is a recognized reaction. While the court can no longer infer consent from their silence or the passivity, the accused can, because of the way in which these provisions are drafted. And the Act compels the court to treat this as a valid defense. Most perversely, the less progressive a man's views are, and I refer to men because it is true that most of the perpetrators of these offenses are men. Most perversely, the less progressive a man's views are about consent, the more likely he is to be acquitted under the statute as it stands. Because what the magistrate who's looking at these cases has to consider is what was subjectively in the mind of the perpetrator. What did he believe? Did he believe that the woman he was about to have sex with consented? And in the context of a society which is perpetuated with rape myths, for example, that we've been through, it is very hard for the state to prove otherwise. In fact, the current law as it stands encourages a perpetrator not, in fact, to take any reasonable steps to ascertain whether or not he has consent from his victim. It affords him, it's better for him to maintain his subjective view of whether or not he has consent, rather than take steps as we say should be required to ascertain her consent. So for all those reasons, we say the rights in question have been triggered, that there are infringements of these rights by the impugned provisions, and that this court should therefore find them unconstitutional. If I can turn quickly to the minister's case. The minister is abiding the decision of this court, but as we set out in our submissions in response, the minister does put up some substantive arguments for the court to consider. We have said that we consider that more opposition than abiding, but I'll take it no further than that. We accept fully that the minister has an obligation to be here and to assist the court with the statute for which the minister is responsible, where the constitutionality of that statute is at issue. In essence, there are three issues that the minister raises. One, a reverse onus. The minister says that there's a reverse onus that will be created by the relief that we seek. Two, that the relief we seek will unjustify, limit an accused's right to silence. And three, that there is in fact no need to amend the statute because Dolus eventualis is sufficient to cure the problem we identify. And to some extent, that third ground is covered by Women's Legal Center. So I'll try and deal with them together as much as I can. In relation to the right to remain silent, the minister says that the relief that we seek will violate not just the right to be presumed innocent, but also the right to remain silent. Now, the right to remain silent was not raised in the High Court by the minister. And the state respondents now ask this court for the first time to consider that argument without the benefit of a lower court's views on the matter and without affording the embrace applicants a proper opportunity to address that. We submit that this court has in the past said in DHB versus CSB 2024 5 SA 335 Constitutional Court that a party should generally not be allowed to argue new issues on appeal that were not raised or considered by a lower court unless there are exceptional circumstances and where it will not cause prejudice and unfairness to a party. We submit that none of those circumstances exist in this case. In Sitawu, this court held that holding parties to pleadings was not pedantry, but was an integral part of legal certainty. We submit that it's plainly prejudicial at the 11th hour, as this affidavit, when this affidavit was filed, to raise a new right that's implicated and effectively make a new case. But even if this court wants to hear that argument, we submit that there's no merit in that ground either. There's no merit in any of the grounds raised. So I'll deal with them in order. First, there's no reverse onus that is triggered by the relief that we seek. The burden does not shift. All that is required, so there's no additional burden on the accused unless he chooses to raise a particular defense. As with any other crime, if he chooses to raise a particular defense, then he must prove that. But the burden remains squarely on the state's shoulders to prove beyond a reasonable doubt that he was guilty of rape. And that's not a reverse onus. At all points, the burden remains on the state. In relation to the right to remain silent, we submit that the question of whether an accused's right to remain silent is implicated by the embrace applicant's relief is nothing more than a red herring. The accused is not required to speak, to put it bluntly. The accused chooses whether or not to raise a particular defense. If he chooses to raise that defense, i.e., she consented, then he must make that case. He will make that case most often in pleadings, and the state will then have the burden to prove that that's not, that there's no merit in that case beyond a reasonable doubt. An accused remains at all points entitled to close his defense without testifying. That is the case in any criminal offense. So it's not clear to us why the right to silence is implicated. We also point out that the minister has made, in the High Court, absolutely no limitations case. The obligation is on the minister to make a limitations analysis in line with Section 36 of the Constitution and the specific factors set out there. That was not done. We say the minister has no way explained to people why men in South Africa should not be held to a standard of conduct and care that requires them to act with reasonable care when they wish to engage in a sexual act with another adult. Why does the Constitution permit that? So we say the minister's case makes really no cogent justification for maintaining a legal position that clearly limits the rights of women and victims of sexual violence. On Dolus eventualis, and I see that clock on the left ticking down very quickly, so you'll forgive me for speeding through the next part, but I'll deal with things in questions if needs be. On Dolus eventualis and the Women's Legal Center argument, we say this: Dolus eventualis has been a vexed subject before our courts. If one looks at the judgments, they go this way and that way. But when one gets to the judgments of the SCA and the Concord, there is some measure of more clarity. What is clear is that Dolus eventualis requires subjective intention. It's not an objective analysis. And so we submit the Women's Legal Center misunderstands Dolus eventualis here. There are two components to Dolus eventualis: the foresight of the possibility of harm, and then reconciliation with that possibility taking place and proceeding with the act. The foresight has to be subjective. Our courts have said this in Humphreys, they've said it in Pistorius, our academic commentators have said it repeatedly. It's a subjective analysis of foreseeability. Dolus eventualis deals with what was subjectively happening in the mind of the accused, not what a reasonable person would have thought. If there are objective factors that the court takes into account, they still have to go towards the subjective mindset of the accused and whether subjectively the accused foresaw the risk or the harm. So Dolus eventualis is not the answer, and it is certainly not the answer in this case where Ms. Holtztrager froze. There were no objective facts that could have been assessed. Unlike in Koko's case, where there were a series of objective facts that could lead the court to Dolus eventualis. In a case such as Ms. Holtztrager's case, Dolus eventualis would not have assisted the court. So we say that there's no basis to that, and it's certainly not the solution to the problem that we bring to the court. The Amos defense, as we call it, is rooted in the law itself, and it's the law which the embrace applicants challenge. On Kels's case, Kels seeks the removing of consent as an element of the defense and suggests that it should rather be a defense that can be raised by the accused. We submit that this asks the court actually to go too far and that it breaches the separation of powers. It may well be that that is a good policy choice for the legislature to take. It may be that that is the way that we should be moving in our legislation, but it's not for this court to decide that. We submit that that is something that should be part of the policy and advocacy that happens as part of government's decision of how to amend the Act. So if you were to adopt Kels's relief, we would submit that that asks this court really to go too far, and the relief that we seek is minimally intrusive. It is tailored to the unconstitutionality that we've identified. It resolves Miss Holtztrager's case, which is a case that reflects the experience of many, many, many women in this country. And it requires an accused to take nothing more than reasonable steps to obtain consent. It is not an onerous burden on an accused. It is simply asking him to take reasonable steps to determine consent. We submit that it's the most sensible and appropriate choice of relief before you today, and one which recognizes that the manner in which the Act currently operates infringes the rights of women and victims of sexual offenses and corrects that unconstitutionality. Those are my submissions, and I think I'm 40 seconds to go. Thank you, Justice.
Thank you, Ms. Rajab Patlenda. You said as you opened your argument, and I agree with you, that rape is a heinous offense. What we'd like to, we just want to get some clarity on some of the points that you have raised. The first one, I'd like I'm interested in the stats that you provided from where you said the conviction rate is 13.8%. Is that based on this defense, or are there other factors that probably lead to the low conviction rate?
Yes, Justice Mhlantla, that comes from the evidence put up by the Psychological Society of South Africa in the High Court. As far as I'm aware, and I'll check with my learned colleague, I couldn't find that in the papers before this court. That's because of how the record was prepared. But I'm very comfortable to discuss with my colleagues and to put that evidence up before the court, should that assist. I referred to it in the High Court. I argued it in the High Court because that was in the papers there. But I felt, even though it wasn't before you in this record, it's an important statistic, and it really is worth this court paying attention to. I just was discovering that last night, that it wasn't in the record, so I'm afraid I apologize for not having it before you, but I'll make that available to you.
Is the defense of consent the sole contributing factor to the low conviction rates, or are there other factors?
I think there are a range of factors. I have no proof to tell you that it's only consent. But what we do know is that, and we can see this from the Magistrates Court's ruling here, the difficulty of proving consent for the state, where what is at issue is the subjective intention of the accused, makes it very difficult to obtain a conviction. And the Amicus will no doubt have many examples of how that is implemented in the courts. But certainly, if you look at the magistrate in this case, she makes it very clear that that is how she understands the law, even in circumstances where it's clear from the ruling that she was really trying to find a way that she would find the accused guilty of the crime, because she believed that all of the elements were there. She says very specifically in her ruling that if there was an objective standard that she would apply, that he would have been guilty of rape.
And that is sought by the applicants is that the accused must show that they took reasonable steps to establish the presence of consent.
Yes, we say that if the accused raises consent as a defense, then he must prove that he took reasonable steps to ascertain that consent. So the way in which the statute is drafted, if you bear with me, the way in which the statute is drafted is that it has, at the beginning of the statute, all of the different offenses. And then in section 56 of the statute has a section called defenses. And so we have tried to craft our relief to comply or to fit in with the way in which the legislative drafters try to deal with defenses. So you'll see even our language is very similar to what you'll find in section 56. So if you look at 56.6, for example, it is not a valid defense to a charge under Section 21 in respect of a visual representation that, and there's some sub-paragraphs, that the accused took all reasonable steps to ensure that where a person was 18 years older, the representation did not depict that person as being under the age of 18 years. So the way in which we've tried to craft our relief is to say that we won't tamper with the text of the offense, but that where an accused tries to raise a defense of consent, because there may well be other defenses, but where he tries to raise a defense of consent and consent becomes the issue, then he needs to show how he determined that there was consent. And we say that he must show that there were reasonable steps taken to show that consent.
Reasonable steps would be for him to explain exactly what the complainant did or said for him to then understand that to be consent.
Yes. So reasonable steps, we don't propose that this court has to set out an exhaustive list of what would be reasonable steps. But there are many instances in our law where that language, in fact, I just read you in this very statute, reasonable steps is referred to, and jurisprudence will develop that shows what is reasonable. So for example, we would submit that reasonable steps is not a particularly onerous burden. It requires an accused to, for example, say, are you okay with this? Is it okay if I do this, for example? It's not asking an accused, and I want to be clear about this, it's not asking an accused to become a lawyer. It's not asking a 21-year-old man to become a lawyer and to use legal terminology before he engages in a sexual relationship with his partner. It's saying, as human beings, we are conscious of our interactions with each other, and we take steps to work out if the person that we're about to engage in this most intimate act with also wants to engage in that act. And as I say, it literally requires the asking of a question. Is this okay? Are you okay?
High Court, when it heard the matter at the time of the judgment, if you could just tell me the Coco matter which was heard by the SCA, which set aside the decision of the High Court. It does not seem like the High Court had regard to the SCA judgment. It only dealt with the Magistrates' Court judgment and the High Court judgment, and seemed to rely on what transpired in the High Court and in the Amos matter to then reach the conclusion that it did. If you could just deal with that and elaborate.
Yes. Thank you for raising that, Justice Mhlantla. There appears to have been some misunderstanding. It comes out from the WLC's papers that the Coco judgment in the SCA was not dealt with in the High Court. That's not correct factually. The judgment came out a short time before the hearing, the SCA judgment. So in our papers before the High Court, we dealt with the Coco High Court judgment. But at the hearing, we dealt extensively with the SCA judgment because it had now become law. And in fact, we took the court through why Coco was different. We are very relieved that the right outcome was reached in Coco. But it was able to be reached because there were so many objective facts that the court had before it to show why Dolus eventualis was applicable. So there were a series of facts. If you bear with me a minute, I'll just find my note on that. But Coco was dealt with in the High Court. The SCA decision was dealt with. We certainly argued it, and the High Court was aware of it. The fact that it's not referred to in the judgment, I can't explain why. But certainly, it may be that because of the timing, it was not in our heads of argument. That may be why the High Court didn't deal with it when the judgment was written. But certainly, in argument, I argued the matter in the High Court, and we did deal with it with the SCA decision. If I can just refer the court, paragraph 63 of the SCA decision in Coco sets out the objective circumstances which undermine Coco's putative defense of consent. And those were, for example, Coco had been informed by the complainant that she was a virgin and that she wished to preserve that status. He had conceded that sexual penetration was not part of the plan for the evening. There was an element of physical resistance by the complainant earlier in the interaction. And finally, that the court found that Coco could not offer a clear and coherent explanation as to how he ended up sexually penetrating the complainant. So in our case, we don't have any of those external markers. And that is where we submit the constitutional defect stands. Where you have those markers, it's relatively easy to get to dolus eventualis, but it's not always the case. In a case where the victim freezes, which is very common, we know from the Amicus submissions, you will not have objective markers. So for example, even in the Zuma case, part of the reasoning of the court was, well, her best friend was close by, there was a security guard outside, there was no physical harm or threat to her physically, and yet she did not resist. That was those were objective factors that the court took into account in finding that there had been no rape. So where those objective factors don't exist, it becomes a real problem to try and prove rape under the statute as it currently stands. Another example is in the case of mental disability, for example. There's a case called Tsoko in the SCA. I'm looking to my junior who knows this better than me. But in that case, the court found that the victim suffered from a mental disability that precluded her consenting. Now, the Act in Section 1.3 actually lists certain circumstances, including mental disability, where consent won't be voluntary. But the court there found that even though there was a mental disability, the accused wasn't aware of the disability. So subjectively, he did not know that she did not consent, and he was acquitted. So in those kinds of circumstances, and there may be many others, the Act at Dolus eventualis certainly does not assist a court in finding an accused guilty of rape, and the Act it makes it more difficult to prove rape. The relief that we seek tries to craft a solution that, as I've said, is minimally intrusive, and that imposes no burden on the accused unless he wants to plead a defense of consent.
One last question for now from me. It relates to the Amos matter. The Women's for Legal Center Trust, if I understand their submissions, is that this could really be a misapplication on the facts of the law by the court. And if that is the case, would that be a basis for the court to declare the provisions to be unconstitutional?
Yes, we disagree with the WLC on this. The WLC makes a series of arguments about why the Amos judgment could have been decided differently. We say, for the reasons I've already articulated, that that's not correct, because on the facts of Amos, Dolus eventualis could never have been proved. The WLC says that Dolus eventualis would have been the solution to Amos, and if she had perhaps appealed, that would have been her solution. But we submit that's not correct on the facts. There were no objective facts that a court could take into account to show that she did not consent. So we submit that that's wrong as a matter of law and fact, and that and it should not distract this court from the case that we bring and the unconstitutionality that we identify.
And I'll pause for now. Justice Chikwe.
Thank you.
Ms. Badlander, I accept that the subjective consent is a problem. When I look at the Act, though, the Act does not elaborate on the kind of consent. It doesn't say whether the consent that is needed is subjective or objective. My first question is, how did the courts end up relying on subjective consent in this kind of matters?
Thank you, Justice Chikwe. The answer to that, well, let me say that I asked my juniors that exact question in our preparation. The answer is this: the use of the word intention in the crime. So if one looks at Section 3 on rape, it says, any person, A, who unlawful and intentionally commits an act of sexual penetration with a complainant without the consent of B is guilty of the offense. And the same format is used with the other impugned provisions. Intention is used. Where intention is at issue, then it's always going to be a subjective analysis. And that, yeah, that goes to the actus reus and the intention. So it's the subjective analysis comes from the use of intention in the provision. Yes.
If intention remains, and then we sort of read in what you have suggested, won't it still be a problem, the issue of intention? Because there's subjective intent has been excluded.
Yes, I don't think it will be
Well,
a problem.
I'm wondering if both terms can coexist in the provision.
Yes. I don't think it's necessary to amend the intention requirement because you still have to prove intention as an element of the crime. But if the defense that is raised is one of consent, then, and if you adopt the additional step that we propose in our remedy of, if he's going to rely on consent, did he take reasonable steps to ascertain that consent? Then I think that what a court will find is that his subjective intention could never have been, his subjective understanding could never have been that the victim consented, where he didn't take any reasonable steps to know that she consented. So the subjective analysis still remains, but we have imported this kind of objective measure of assessing whether his conduct, I suppose to be fair, it's whether his conduct was objectively reasonable. I see the difficulty. We are careful of not doing too much damage to the statute as it stands. And I think that the way in which we craft the relief will still enable an objective analysis to be effected through the defense.
The challenge based on constitutional invalidity is that the best way in which this could be solved? I'm asking, there's a lot in all the written submissions about the judgments. And there's the point that Carls is making, that perhaps the way in which the courts have looked at this and at this is problematic. And I was wondering to myself whether, in fact, the best way to challenge it was not to challenge the decision themselves instead of the act. Since that the act does not define consent or does not elaborate what kind of consent would be necessary, whether the best way is to challenge the decisions themselves.
So, Justice Cheekley, we submit that we would disagree with that, first of all. What we see in our courts, first of all, is a haphazard way of interpreting the Act as it stands. That, and I don't want to give evidence from the bar, but it is clear if you just look at the judgments that there are many ways in which the courts have tried to deal with this provision. The courts need some certainty about how to implement this. The low conviction rates show you that there is a problem. We submit that the problem lies in the subjective standard. The subjective standard comes from the use of the word intention and the element intention in the crime. In Koko and the SCA, I think they make reference to that, but I'll find you the paragraph number. I'll ask my juniors to find the paragraph number. They refer to the requirement of his subjective mindset. So, and the same with the magistrate in this court. In this case, she makes it clear that is requirement. The academics that have written, there's a Schwickard article in our academic bundle. Schwickard makes it clear as well that the standard here, by using the word intention, is a subjective one. So that's not going to change. We don't think that just simply challenging individual decisions as they come out is the solution where there's an act that is plainly unconstitutional, we submit. There is an obligation on us under international law to repeal legislation that discriminates against women. That comes from CEDAW. So I don't think it's enough to simply say, shouldn't we be challenging individual decisions, because we will have an inconsistency in a context where we really require legal certainty. My juniors have pointed out that it's paragraph 62 of Koko in the SCA, where the subjective standard is clearly dealt with.
And
I don't know if that answers your question.
On my side, on defense's Section 56 is on defenses. Is the reading in not more appropriate on defenses?
Is there, do I understand the question correctly, is there a more appropriate reading in than what we
Yes.
propose? You know, justices, we have really tried to look for a more elegant reading in, because I accept that it is a little unwieldy. But when I went to the foreign law to look at what has happened in Canada, the UK, New Zealand, it's clear that other jurisdictions have equally battled, because all of these, first of all of those countries previously had statutes that looked like ours and then amended them. That's all dealt with in our heads. But when one looks at how they've corrected the problem, it looks very much like this reading in that we've proposed as a 56(1)A. So I'm just going to read it to you, and then I'll see if there's a more elegant way to craft it. But we say, wherever an accused person is charged with an offence under any one of sections 1 through to 11A, it is not a valid defence for that person to rely on a subjective belief that the complainant was consenting to the conduct in question unless the accused took objectively reasonable steps to ascertain that the complainant consented to the conduct. That was as simply as we could put it. One could, I suppose, simplify it to say, wherever an accused person is charged with an offence under one of the above sections, it's not a valid defence for that person to rely on a subjective belief of consent where they did not take reasonable steps to ascertain that consent, something like that. But it's very hard to get, as I say, to a more elegant version of that formulation.
Thanks, Ms. Glenda.
Thank you, Justice Speaking.
Justice Kolapen?
Thank you, Mr. Badlinda. This is a very difficult case, and it's a very difficult issue, because it almost seems that when one reads all the submissions, that we're trying to deal with a deep-seated, ingrained problem in our society that has various components to it, and we're trying to straitjacket it within the law. And in one of the submissions I read, it was said that the law is not everything. The law is not also nothing. And the question here is whether the law can be something, and I'm not sure about that. But the difficulty I have is that, on that issue, is that ultimately whether we take the reasonable steps approach, whether we take the WLC approach, or whether we take the coercive circumstances approach, it may well be that we're still revolving around the idea of consent. But we might call it differently, and we might locate it differently. And given that, is it not the real risk that whatever we do legislatively, that the way in which we filter and receive the evidence that is meant to satisfy any of those standards will still see us falling quite woefully short of meeting the standards we want to set? So what I'm asking really crudely is that we're trying to fix a problem through sort of tampering with legislation, but it may not get us there. I don't know if you want to respond to that, or you want to deal with my question.
Now, I would like to respond to that,
Okay.
Justice Kolapen. I think that's correct, but it is often the case that when this court is called upon to weigh in on the constitutionality of a statute, that the court is trying its best to do its job with, as the arbiters of law. And law is not everything, and it's not always a solution, and that is why, so I agree with you on that, Justice Kolapen, it is why we raise the context in which all of this happens, because social norms, myths, patriarchy operates in equal measure to law. And so what this court has said in Prinsloo versus van der Linde is that this court has to consider, when it's considering the constitutional analysis, that it has to consider the context in which the case occurs, the context in which the rights are implemented. We say it is not okay for this court to do nothing in the context where there is clearly a problem. And we disagree that there is no problem, as some of our colleagues say there is. We say there's clearly a problem, it's evidenced by our client's experience, that the relief that we seek would allow this court to identify the problem, to try to fix it in a minimally invasive way, and then to leave it to the legislature to decide how best to deal with this incredibly complex issue. We are not here to say that using coercive measures and consent as a defense, as Kells argues, is wrong. That's certainly not our argument. We're saying that's for the legislature to decide. It's not for this court to decide. But we would submit that this court cannot leave litigants without a constitutional solution in circumstances where we submit the infringement is so clear.
Good. That brings me to my two questions. I just want to understand your response to earlier question in that, are you saying that the failure to take reasonable steps will then mean that there is intention in the manner in which it's understood, or that the crime is committed not intentionally but negligently? I just need to see whether failure
Yes.
renders the requirement of intention fulfilled, which I can't think would be the case, because the failure to take reasonable measures can't convert something that was unintentional to being intentional. And therefore, the submissions you make in
Would be that it would be
page 23
negligence.
is really, what you're saying is that the position that the High Court adopted and which you support is that you can convict someone on the basis of pure negligence. Is that?
Yes.
I mean, you're saying that it's not
That's
objectionable.
correct, and we also say in our submissions that negligence is blameworthy in our law. That there is nothing wrong with criminalizing negligence. We
just
do that in
want
culpable
clarity on-
homicide. We do that in this act itself. So yes, Justice Collins.
But because my question that arises out of that is that if one convicts on the basis of negligence, and even though it's blameworthy, it's seen as a lower level of blameworthiness. So when this goes to Parliament, for example, is there real risk that Parliament might say, well, if you convicted on the basis of negligence, then we're not sure whether the minimum sentences that are provided for currently should remain. And they should be reduced because, in a sense, from a moral and a culpability point of view, it ranks lower. And my question is, what does that mean for the fight against gender-based violence? That you now have a category of convictions that are based purely on negligence.
Yes.
So that's my second question. Yeah.
Yes, Justice Coleman, I think you raise, as usual, a very critical question. I think that may well be a problem. I can't argue that it would not be a problem. I would disagree that it's a lesser offence.
Less offense, but in
It's
terms
not,
of
and some of the, yes, and some of my colleagues have said it would reduce it to a competent verdict, which we submit is wrong. But I think that those are the things that Parliament's going to have to grapple with.
Okay.
Because if minimum sentencing must then change to accord this the appropriate weight, so be it. Parliament is going to have to grapple with the gendered context in which this all happens, with the importance to which is given to the crime. But that can't be this court's job. This court has to look at the provision, see if it's unconstitutional, and declare it so if it is. And in the statute as it currently stands, there are already negligence-based crimes. I just point the court to it in section 15 and 16, statutory rape and statutory sexual assault. They already exist in the statute, and negligence is a standard there. Yeah.
And then just finally, if we are of the view that this will make a difference, how will it make a difference in those kind of cases where, in a sense, the response to sexual violence is what has been called peritraumatic, can result in an inability to verbalize, an inability to act in a way that indicates. And so if one is ultimately to use the reasonable steps test, then and how does the reasonable steps test really happen in the context of that particular phenomena? The test may well be answered in favor of an accused person under those circumstances, because an accused person may well be able to say, well, even having followed the reasonable steps approach, this is the end result, that there was nothing that would say to me that the consent that I thought I had was not genuine.
Yes.
And so is that perhaps an area that will never be addressed, and we have to accept that this will be.
Yes.
And then just on that step, the Canadian approach that you referred to in your heads speaks about reasonable steps in the circumstances known to the accused at the time. That would seem to me bringing some level of subjectivity into that test.
Yes. So if I can answer the first part of the question first, there are absolutely going to be circumstances in which rape is not, you can't prove rape. But the mere freezing of the victim doesn't necessarily mean that reasonable steps won't result in a subjective understanding of whether there was consent or not. Because, for example, if you were to take the Toko facts, assume that all of those facts of a conversation before the act was done about what was going to be okay and what was not going to be okay, a history of a relationship between the parties where sexual penetration was not going to happen before marriage, a resistance from the woman before sex happened. All of those kinds of facts will remain relevant even at the moment, even if at the moment of penetration she freezes. So you can't. There's never going to be a complete fix for every factual scenario that we face. But what we can try and do is to find a tool that fixes as many of these scenarios as possible. We submit that the reasonable steps, at least in the Koko analysis, he would have to have said to her, I know you didn't want to have sexual penetration, but is it okay if we now do that? And then, he would be able to say, when he raises a defense of consent, I specifically asked her what she was willing to do, and it was clear that she had changed her mind, and so I proceeded. That would be his defense.
Sure. And do you accept finally that that might work better where the parties are known to each other?
Yes, that may happen in a relationship where the parties are known to each other.
Like in the case that you that you referred to in respect of the second applicant, it might be much more difficult then to establish because there are no objective facts, as you pointed out earlier in your argument.
Yes,
But I suppose it is what it is in a sense that that's the mechanism you adopt. It's, you say, for 18 months. And ultimately, it may well be open to Parliament if we go in that direction through its own participative and deliberative processes to determine what's the best long-term remedy. Yeah.
Yes.
Maybe that approach, it may be the CAL's approach, we don't know.
Yes, Parliament will decide. But I want to simply say this. Even where you have just met the person 10 minutes before, we submit that it is still incumbent on two individuals who are about to engage in this incredibly intimate act to ascertain that both of them want to do that. And we submit that it's not onerous. It is not removing the romance from a passionate situation. It is simply taking a minute to ask a question in common language, not legal language. Are you okay? Is this okay? Can I do this? That's all. And we submit that even if you met the person 5 minutes before, that would be possible.
Ms. Raja Bandunda, in order for this court to confirm the declaration of invalidity, it must be satisfied that the impugned provisions are inconsistent with the Constitution. Your submission is that the impugned provisions infringe the constitutional rights of complainants, their rights to equality, dignity, privacy, bodily and psychological integrity, and freedom and security of the person by enabling a defense of unreasonable belief in consent. How does it follow that allowing a subjective belief in consent infringe these rights? I'm having some difficulty in following the submission that allowing for subjective unreasonable belief in consent shields an accused from liability, and that this amounts to an infringement.
Thank you, Justice Theron. So, Justice Theron, our argument is this, that if you take the example of rape as a starting point, this court has said clearly that rape itself is a violation of the rights that we refer to: privacy, bodily integrity, freedom and security of the person. in that context where an accused is, and in addition to that, let me say this, there is a gendered lens through which all of this operates, that this court has recognized. Where one then allows, in that context, an accused's subjective mindset to be the determinate factor of whether or not there's consent, that is an invasion of the victim's rights to bodily integrity, privacy, and freedom and security of the person. Because the only analysis that a court is making there is the perpetrator's subjective mindset. There is a power imbalance in that equation that is a gendered imbalance and that operates most harshly on women and in a way that violates their very dignity. So I'm not sure if I'm answering the question correctly, Justice Theron, but the subjective element as it currently stands puts the focus on what was in the mind of the accused. That becomes the only issue that the court has to consider, virtually the only issue that the court has to consider. And that's the basis of the infringement.
The order that was made by the High Court, can you refer, where can I find it, please? I think it's annexed to the founding affidavit.
Yes, if you just bear with me a
Page
minute.
51.
Oh, I'm so sorry, it's actually just in front of me here. Yes. Thanks.
Yes. Do you have, it's page 62 of volume 1.
Yes. Okay.
You see paragraph 1 of the order, it mentions the sections. And I'm not certain, and I speak only for myself, that it identifies the constitutional infringement. It says it's declared invalid and inconsistent, and then usually it should follow after that, to the extent that. And I'm not sure that what follows identifies the constitutional infringement that we're dealing with. Because it then says, to the extent that these provisions do not criminalize sexual violence where the perpetrator wrongly and unreasonably believed that the complainant was consenting. Do you understand that?
Yes, and it should have said to the extent that they infringe on the rights to equality, etc., etc.
And I'm struggling to make that link.
Yes.
That even if we do say that, I'm struggling to make the link. How does the unreasonable belief that the victim was consenting infringe those rights that are referred to in sections 3, 4, 5, 6, 7, 8, 9, and 11?
I suppose the simplest way to explain it is this, that the unreasonable belief permits the offense. So the unreasonable belief permits a rape to happen. And that's the link. That if all we cared about was was the subjective intention of the accused, did he think that she consented or not, the effect would be to ignore all of her rights. So the effect would be, it's really just what the man thinks. Does she consent? So for example, I know marital rape is no longer a crime, but we are married, as an example, and therefore she must consent to sex. As a very simple equation. That ignores all of the rights that are protected then when there's an unreasonable belief.
If I understand your answer, the problem then is how do we interpret and find consent, and how do we find where there has been no consent?
So yes, and when we try and answer that by saying, how does the perpetrator determine consent, right? The perpetrator determines consent either by objectively verifiable circumstances or by taking reasonable steps to determine consent specifically.
Yes.
But without those, it's really, we back to the subjective intention.
And the legislature says it's an offense where there's no consent. Isn't the problem really how we interpret and apply consent? And when I say we, I refer to the judiciary.
Yes. So if I understand,
Instead of with the legislation. So the legislation says if there's no consent and the act occurs, it constitutes rape. Isn't it the function of judicial officers then to interrogate the question of consent and to interrogate it broadly to cover the possibility of where there can be no consent through a freezing of the victim?
what's missing in that analysis, Justice Thuran, I would submit, is the fact that the legislature has used the word intent in the provision. So the intention requirement is what takes us to the subjective intention of that a court can't get around. So that even if a court was looking at consent, so for example, in Miss Holtztrager's case, the magistrate said very clearly, it was clear she did not consent to sex. She says that specifically. It was clear she did not consent to sex from all of the evidence that was run, including medical evidence. But, she said, I still can't convict under this act because intention requires a subjective analysis, and subjectively, the state was not able to prove beyond reasonable doubt that he knew that she wasn't consenting. So it's not simply, consent is one of those factors, but it is not the whole analysis. Intention is the core analysis there.
But I thought we were here in court about consent today.
No, we're in court today about intention and consent. It's the combination of those two factors that you will find in each one of the impugned provisions. And it's those combination of factors we say that triggers the problem.
Doesn't the definition of rape also refer to intent?
Yes, yes, absolutely. Every one of these crimes has both intent and consent.
So if we tinker with intent, to what extent are we tinkering with it? What is the applicant asking the court to do in relation to intent?
I suppose what we're doing is effectively asking this court to impose an objective measure of intent, which is what Justice Collopin was, I think, asking me earlier. So the effect of our relief would be to say that where the accused, and only in the situation where the accused wishes to raise a defense of consent, he would have had to take reasonable steps to determine that consent. A court would then have to evaluate whether those steps were in fact reasonable, whether he took steps at all, and whether they were reasonable. The state would have to prove where consent was raised, and it's important that we understand that this only happens in the world where an accused pleads a defense of consent. In that situation, the state then has to prove that objectively, all of those objective facts show that subjectively he knew she didn't consent. So I suppose the logical answer is it's taking it away from a subjective intention and closer to an objective analysis, which then gets us closer to negligence.
Okay. Your answer leads me to my next question. When we talk about negligence, are the embrace applicants, in terms of the relief that they seek, if the relief is granted, we would then be criminalizing negligent rape?
Yeah, and we said there is nothing wrong with that. We criminalize negligent conduct. In many, we criminalize negligent murder.
Yes,
Culpable
but
homicide.
this is now, I think my question is to me a little bit more difficult because you readily conceded the first one. Does this court have the power to create new offenses?
Well, what we're asking this
We
court...
then, and I'm basing this on the answer that you gave, we'll be creating the offense of negligent rape.
Justice Thuran,
Isn't that an overly intrusive remedy which would usurp the power of the legislature?
Justice Thuron, my immediate question is, what is the alternative for this court, first of all? I don't submit that this court has the power necessarily to create new offences. But the alternative is for this court to find... Sorry,
Sorry to interrupt you.
not at all.
If, that's the next step. If this court does not have the power to create new offences, then it cannot create a new offence of negligent rape. And we need to answer that question first without looking at the facts of this matter as to how it would affect the victims of rape. We need to answer the question of the power of the court independently first. Does this court generally have the power to create a new offence?
Let me turn this around a little bit. What we bring to this court is what we see as a patent unconstitutionality. And it is the job of this court to declare all conduct and acts unconstitutional as such. If this court is of the view that its concern is with the remedy that we propose, not the unconstitutionality, but the remedy, then we must talk about that, perhaps. Because whatever happens, we submit that this court must declare the act unconstitutional. And if this court decides, well, we'll leave it to Parliament to fix, so be it. We've submitted that it is permissible for an interim reading in until Parliament does whatever it is appropriate to do, whether that is to create another offence, whether that is to adopt a coercive standard, whatever that may be. But it cannot be that this court does not declare conduct or an act unconstitutional where it finds that it is so. My learned junior is just pointing to me to something, if you bear with me. It's always good to have very clever juniors, and I have 3 of them. Justice Thuron, my junior points me to the Masia case. And in Masia, this court created a new offence, that of anal rape. So if one looks at paragraph, in the order of Masia, that's paragraph 74, the order is to make a declaration of invalidity and confirm the High Court judgment. And then it says, the order of the regional court referring the criminal proceedings to the High Court for purposes of sentence in terms of a particular provision is set aside. The common law definition of rape is extended to include acts of non-consensual penetration of a penis into the anus of a female. So it is an extension of the existing law. Now, I know that your answer is going to be that's not the creation of a new offence.
It's not a creation of a new offence. It was still rape, but it just broadened the categories.
Well, sorry. Is that so different,
clearer.
my lady?
If we look at murder,
Yes.
murder with intent, murder.
Yeah.
Negligent murder, culpable homicide. 2 separate offences.
But you would submit that it's not that different, it's not necessarily 2 different offences, that it is that the relief that we see could actually be seen as an extension of the offence. So if you just bear with me as my mind just works this out, I think that if the offence is rape, for example, it would still remain rape in effect. It's not creating a new offence called negligent rape. It's an extension of how we understand rape. And that this court would be allowed to do in line with Masia.
In your submission, Ms. Rajapatla, you identified the problem in rape cases as being the reliance on the subjective mens rea standard. And if I understand your submissions, the definition would remain the same, namely the unlawful intentional sexual penetration of a complainant without their consent. The remedy that the embrace applicants seek, they don't seek to change the definition, which would still require intention in Dolus. Now, how can the relief that's being sought by the applicants be reconciled with the definitional elements for the charge of rape?
Because Justice Saran, we say that we locate the fix in the defense, that this only applies, it doesn't apply in every rape. It's not going to apply in every rape. It's only going to apply in rape where the accused raises a defense of consent. And the way in which the statute is currently structured is to place defenses separately to the offense in Section 56. So that is the way in which we've crafted the relief, to leave the offense intact, but where there's a particular circumstance of the raising of defense of consent, that it's dealt with in the way that we suggest.
Is there not a way to deal with it without tinkering with the legislation? And it brings me back to one of the earlier questions I asked about judicial application and interpretation as to what is the meaning of consent. And the problems that we see may go back historically and influence how judicial officers interpret and apply the meaning of consent. So my question really is, should judicial officers not be interrogating whether there is meaningful consent?
Yes.
And that would cover the test that the embrace applicants seek to advance. In other words, and I know this is a long question, I don't really like asking long questions, would a reading in of the word meaningful before consent offer a suitable remedy? If you need more time, you can address it.
I do want to consider that, because I'm worried that that itself may open a debate of what's meaningful consent, what's non-meaningful consent. I think if we take a step back and look at what brought us here as a way to working out what remedy we seek, what brought us here is a magistrate saying to us that the law as it stands, as she understands it and as she implements it, requires only an analysis of the subjective intention of the accused to have been proved, and that the state was not able to prove that because there were no objective indications of a lack of consent. What we see in the courts is an inability, is a lack of certainty, is an inconsistency in how these provisions are being dealt with. What the embrace applicants seek is, why we come to this court, is to assist us with that problem. We persist in the fact that we think that the Act as it's framed is unconstitutional. And you can see that even from the foreign jurisprudence where the countries that we refer to, the UK, the US, Canada, and New Zealand, have all moved away from a formulation of a statute that looks like ours to incorporate this reasonable steps requirement. There's a reason that they've done that, because they themselves believe that this, as it's presently formulated, is unconstitutional. But if this court is not convinced of that, then we would ask this court to attempt to fix the problem we bring to you, which is to give guidance to our magistrates, our high court judges, about what this provision means. If it doesn't mean, if this court finds that it doesn't mean subjective intent means not looking at objectively verifiable manner of determining consent, this court must say so. What is absolutely clear, just in my time of working on this case, is that this lack of certainty is resulting in daily injustices to women in our magistrates' court, in prosecutions for rape not happening at all, let alone not being successful. So there is very clearly a problem here. And we come to this court to solve that problem. How we solve that problem is less our concern. We've suggested a manner in which we think it should be solved that's constitutionally compliant and that's minimally intrusive to the statute. If this court disagrees with us, there are other ways to solve it, but we impress on the court that what you're solving for is not an ideological concept. You're solving for a practical reality of how this provision is being interpreted in our magistrates' courts.
Exactly, Ms. Rajabadlinde. How the problem is solved is not so much your problem, but it's the problem of this court.
I'm afraid that is correct, Justice Theron.
We have to interrogate.
Yes.
And when I hear your submissions about lack of certainty, inconsistency of application, then it seems to me the answer lies more in this court giving guidance. And I'm not saying that's the answer, I'm just raising it as a possible solution where even if we don't read in the word meaningful before consent, this court could say that if that consent must be interpreted to mean meaningful consent. And if that was the test of meaningful consent, even if we don't go as, even if there may have been a subjective belief, if we interrogate meaningful consent, like in the Holtztrager matter, there probably would have been a conviction. If we interpret consent to mean meaningful consent.
Justice Theron, the one issue I just wish to raise for the court to consider, should the court wish to go in that direction, is what I've mentioned before, which is that it's not just about consent, it's also about intention. So if one is simply to read in meaningful, it would not move us away from a position in which the subjective mindset of the perpetrator is what is evaluated. And that, in the context of these rape myths, and that's why I referred to the rape myths, makes it very difficult still to prove. So, for example, in a ridiculous example, extreme example, if a man genuinely believed, if he came from a remote area where he had no exposure to all of these laws, and he genuinely believed that if a woman smiled at him, it meant she wanted to have sex with him, then it would be impossible for a court to convict him of rape. And meaningful consent would have to encompass that.
Where a court has to interrogate subjective belief, it's got to be reasonable.
Sorry, Justice Theron, it has to be reasonable.
It's got to be reasonable. And if you interrogate that in the context of meaningful consent, it must be reasonable.
Yes, we say that as the statute as it currently stands doesn't require that subjective consent to be reasonable. It's a different inquiry that has to happen. So if that is what the court thinks that the statute means, then we would ask the court to say that specifically. But as it currently stands, the subjectiveness of the intent, there's no reasonable element to the intention there at all in the statute.
If we were to read it as meaning meaningful consent, on the flip side of that would be that sexual penetration without meaningful consent would be prima facie unlawful.
Sorry, Justice Theron, I'm going to ask you to say that again, please.
The flip side would mean that sexual penetration without meaningful consent of the complainant would be prima facie unlawful.
Yes. Yes.
Yes, thank you. Thank you, Ms. Rajapatla.
Thank you, Justice Theron.
Thank you, Justice Mhlantla. Ms. Rajapatla, I just have one difficulty. Is the test not really a factual inquiry based on the circumstances of the particular case and the evidence adduced by the prosecution that actually answers your problem? For example, in this matter, if the prosecution adduced evidence relating to peri-traumatic responses and the freezing of a complainant in certain circumstances, wouldn't that have assisted, for an example?
Justice Musi, that may have assisted, but we submitted wouldn't have gone far enough. So in this case, there was extensive evidence led. There was evidence led so the witness, the complainant herself testified to her response of freezing and being in a trance. She testified to her inability to move because her legs were pinned behind her or above her ears. She testified to the fact that she was in a state that she wasn't able to get out of without his assistance. We also had medical evidence, and the medical evidence in this case testified to the extent of the injuries caused. So there was all of that evidence, and even with all of that evidence, the magistrate wasn't able to get to a conviction of rape, all because of the subjective intention of the accused. So it's not Of course, every case is an assessment of the facts of that case, but we're suggesting that the Act as it stands impedes on us getting to a conviction in circumstances where it is clearly there is no consent.
But then it is more a question of how the presiding officer assessed the evidence. Not so. That is actually where the problem lies.
I think it's absolutely always a relevant factor, how the presiding officer affects it. But even in this case, you can see from the magistrate's ruling, which is comprehensive, that the magistrate assessed the evidence correctly, that if she was wrong, she's only wrong that there was a subjective element of intention that she was bound by. She wasn't wrong on the facts, and the facts wouldn't have changed her conclusion in this case.
Isn't it also a fact that in most cases where intention is the required mens rea, the court looks at the objective facts in order to ascertain whether the accused could subjectively have the intent to commit the offense?
Yes.
And is that not where the problem is?
Yes, the court has to look at objective facts to get to the subjective intention of the accused. That doesn't make it an objective analysis. It means that you're looking at objective facts to determine subjective intention. Our courts have actually dealt with that. This court has dealt with that specifically. And I can give you the reference if needs be, but it doesn't change it into an objective analysis. It's still looking at factors to determine subjective intent.
But it's an objective analysis in order to get to the subjective thoughts.
It's in a...
Because the court can't know what went on in an accused's mind. You use objective facts in order to get there.
It's an assessment of objective facts to determine subjective intention.
Thank you.
Justice Musi.
Ms. Roger Butlander, can I just ask, in this whole inquiry, are we concerned with reducing the incidence of rape by making the changes that are proposed, or by increasing convictions, the number of convictions, because those two may well not be related? Or are we concerned with something else? Clearly, if by a change to the law we could have a meaningful effect on the extent to which women's or anybody's sexual rights are violated, that would be important. The test that is proposed in the reading in may result in some increase in convictions. I must say my colleagues will have different experiences. My own experience in the High Court, dealing with petitions and appeals from the regional court, I didn't come across a case, I don't recall, where the outcome turned on the accused's subjective belief of consent. I'm sure there are, you have a client who was one such case, and I'm sure there are. I'm not sure that they are a big proportion of the cases. But either way, is the aim just to secure more convictions? Or is the aim, by securing more convictions, to actually reduce the incidence of rape? And is there any evidence on either of those two matters that there will be a meaningful increase in convictions and that it will have a meaningful effect on the incidence of rape? I ask that because you know that the definition of rape was legislatively extended very widely. Penalties have been raised, including life imprisonment in a number of instances, and yet we still have the avalanche of gender-based violence. So what are we really about here? And if I may also add, what might be important is the way that victims of rape experience a rape trial. But it seems to me, whether it's the coercion test or the reasonable steps test, if an accused is going to run the case that this wasn't coerced and wasn't without consent, that is still going to be explored in the rape trial. The complainant is still going to have to go through the same trauma of reliving it and having her reactions to things tested. But to go back, what are we really about here? Are we reducing the incidence of rape or just increasing the convictions, or are they related?
Thank you, Justice Rogers. Let me start with your second question. The fact that it may be that many of these cases don't reach an appellate bench is clear from Miss Holtztrager's case, where she didn't appeal. The reason she didn't appeal is that she was told that there were no prospects by the prosecutor. So the fact that that's why I have in my submission, I've repeatedly talked about the magistrates' courts, because I think that that is where the bulk of these cases start, not all of them, but they don't often find their way to an appellate court because, for one thing, it's not really within the hands of the complainant to make that decision. So I take your point that you have not seen these, but I would submit that that's not a reflection of whether or not there are many of them. On the issue of what we're trying to solve, I think it's a nuanced question, but it's an important question that is a difficult one. We know that rape has many factors, that the reason that if one has to look at the reason why gender-based violence is so prevalent in our society, there are many factors for that, and the academic sort of learned commentators are much better placed than I am to tell you this. But they have written extensively about it. It relates extensively to our brutal past. It relates to our huge unemployment stats. It relates to power imbalances. So we know that there are all of those reasons why our rape statistics are so high, our gender-based, our sexual offenses statistics are so high. We're not asking this court to fix the entire problem. This court can't do that. We know that courts can only do part of the work, that there is a huge amount of social work that must be done to fix other parts of this problem. But where it comes before this court is through this act. And it's the application of this act that this whole context of gender-based violence finds itself squarely in the court system. So if you ask me, are we trying to reduce the instances of rape? Of course we are, but we don't submit that this case will necessarily do that. It will change, if you adopt the relief that we seek, it will change the way in which individuals behave because it will require them to take steps to determine consent. So it is going to have an effect, if you adopt our relief, on social behavior. But
of course, the law already says that you can't violate another person sexually without their consent, and yet it happens all the time. Without
Precisely.
consent. The fact that the law says so doesn't seem to affect the way people behave. It may, in a few incidents, maybe, I don't know, I think you earlier drew a distinction in one of your submissions. You said, ironically, the less progressive the man is treating the man as the perpetrator, the more likely he is to have a wrong view of things. So there may be a small class of persons who come to learn that you must take reasonable steps to ascertain consent, and they might do that. And would your argument be that even if that only happens in a very small number of cases, it's a change that should be made, even if it has no, if we look at statistics over the years, if we see no change in the graph?
Well, let me answer it this way. I don't think that it will have as small an effect as the question suggests. I think that the effect will be more significant than that. I think that there may well be resistance to the relief that we seek because of all the arguments of removing romance from these things. But those are arguments used to shield people from unlawful behavior. I think what must be at the forefront of this court's mind in considering this, when evaluating these issues, is that where there is an unconstitutionality, I keep coming back to it, this court has to declare it so. The effect may be things we can't anticipate entirely, but that's not for this court to decide. I think the effect of the relief that we seek is not simply to reduce the incidence of rape, and it's not simply to increase prosecutions, but we say it will have the effect of doing both those things in some measure, and that's important. But it shouldn't be the primary consideration that this court has to deal with. It will be an effect of the court's judgment. This court is already one of the most progressive in the world on these things. And the effect of our judgments, for example, on rape and talking about how rape happens in a gendered way is transformative. But the basis for all those judgments at its outset is the unconstitutionality. I'm not sure if I'm answering your question very eloquently, Justice Rogers.
And I was interested to know if there was any evidence to suggest how the change that is proposed here is going to affect the practical outcome? Because it seems to me that we should be primarily concerned with whether the definition of the law as it stands at the moment is resulting in more women being violated without their consent than would otherwise be the case. More people getting away with it, if I can call it that. But I think you have...
Yes, the short answer is we haven't put up any evidence. We don't have that evidence. The amici may be able to assist with that.
And then if I can just go back to my sister Taron's question about the rights violation. I also find this quite difficult. I can understand that you say sexually violating another person without their consent is the violation, and yet this law allows the person through intentionality to, as it were, get away with it if they subjectively thought there was consent. So I understand your point that it's not consent as such, because in your client's case and in many other cases there is not in fact consent. So there's that violation, but the accused still gets off if he subjectively believed it. You now propose to raise the reasonable steps test. That doesn't exclude the rights violation, because the accused may satisfy the reasonable steps test and yet the complainant may not have consented. So even your remedy allows the violation, it's just a lesser violation. But now this brings me to the question of policy choices. It seems to me that if one looks at the Bill of Rights, if anybody violates another person sexually without their actual consent, whatever they thought, there is a rights violation.
Yes.
What remedy should be granted for it might be a different matter. And there's a policy choice for the lawmaker. Are we going to criminalize knowing wrongdoing in any instance, or are we only going to criminalize negligent wrongdoing? And this comes in a number of fields. If your argument is right, property owners may say, well, why should an unreasonable belief by a person when they took my things that I had given consent be a defense to theft? The law makes a choice as to what to criminalize. That isn't the whole of the remedies that are provided. There might be civil claims for damages for rape. There might be a claim for constitutional damages. There might be other remedies. But surely the choice as to what you criminalize is ultimately a policy choice rather than a fundamental rights-based choice. And it's not for the courts to say that the crime should be negligent rape rather than deliberate rape, any more than it should be our choice to decide that the common law theft should be negligent theft and not knowingly wrongful theft.
Yes, that's correct as a matter of principle, Justice Rogers, but this court routinely declares policy choices of government unconstitutional.
But that is a clear rights violation.
Yes.
Now here the law hasn't said to anybody it's okay to violate a woman sexually without her consent. The law doesn't say that. The law, in fact, says you can't do it without their consent. And the Bill of Rights would be enough to make that clear. But now the question is, what should we criminalize? What should be the subject of civil claims for damages? What should be the subject of constitutional remedies? Why is that choice a rights violation?
Because
why is it
the
a
choice...
rights violation to say that a person should be convicted or should escape conviction for a genuine but mistaken belief in consent?
Yes. On that last part of your question, the idea of honest but mistaken belief in consent has found its way into some of the foreign law. And even in those situations, the accused can be found guilty, even where there's an honest but mistaken view of consent, where he failed to take reasonable steps to ascertain consent. But that's just as an aside. Justice Rogers, we submit that there is a clear rights violation here as a starting point, that where the legislature has made a choice to craft the definition of rape not just around consent but also around intention, where that intention is subjective intention. We know that. Our courts have said that the use of the word intention in this situation, the SCA said this in Koko, is a subjective intention. Where that is the way in which the statute is crafted, then that results in the rights violation. But if this court thinks that I'm wrong on that, and that in fact that's not what the statute means, then we would ask this court to say that, so that our lower courts apply this in the correct fashion.
My question is on the premise that subjective, even unreasonable, but an honestly subjective belief in consent on the current concept of intentionality is a defense, as it is for all offences, where intentionality is an element. Intention is the form of mens rea in a great many crimes, and in all of them, knowledge of unlawfulness is a component of intent. So it is always, you could go to any number of statutes and say, well, is it a rights violation in this case to make it intent rather than negligence? Just doesn't seem to, if the law is saying it's okay to violate if you mistakenly believe the complainant has given consent, then I would say that's a rights violation. But the law doesn't say that. The law is only concerned with under what circumstances will it send the man to prison.
Well, the law says...
So it's concerned with one element. To what extent should we criminalize this rights violation? It accepts that there's a rights violation. I'm sure that all the members of the court, the one thing they are clear, for example, is that your client suffered a rights violation. The question is the remedy, and is it unconstitutional that the remedy does not include a conviction for rape?
Justice Rogers, if you just bear with me, my junior's passing me something. The Act, I think we're perhaps beginning from the wrong premise. You are correct that the Act says you may not have sex with a person who does not consent. And the Constitution says, and international law, you know, we agree about that. But what we brought to you today is an Act that doesn't just say that. It says you must have intended to have sex with her without her consent. Yes. And if you raise a defense of consent, you may do so and say, and your basis for that defense is your pure subjective belief in consent.
That's not legitimizing the violation. It is merely setting a condition under which a person may or may not be criminally convicted. It may not affect whether they are liable for civil damages or for constitutional damages or for any other form of remedies. But it affects that. That is my concern, and it, I suppose, ties into an extent with the remedy that you propose, because your remedy doesn't get rid of that rights violation, because a person may still get off even though they took reasonable steps and even though there wasn't actual consent. You say, well, the fault element should be drawn a bit closer to strict liability, but you don't say that there should be strict liability.
No.
Does your remedy necessarily entail, as it were, vindicating the rights of or balancing the rights of the complainant as against the rights of the perpetrator? By criminalizing negligent rather than knowingly unlawful conduct, are we limiting the rights of the accused person? I'm not going into reverse onus, that can be sorted out, needs to be, but are we, as it were, solving one limitation by creating another?
Well, the issue of the balancing of the rights of the accused was raised first by the Minister in the High Court. The Minister's argument, as I understood it, my learned colleague will correct me if I'm wrong, was that the formulation of our relief and the effect of our challenge would be to limit the rights of an accused. We submit that that's not correct, that the way first of all, the way the statute currently stands does not balance the rights of the complainant and the accused at all, because the analysis is purely on the subjective intention of the perpetrator. We submit that in our formulation, there's a greater balancing of rights because an accused would be able, one, to raise a defense that she consented, two, to show that he took steps to verify that consent. And the burden would then be on the state. The burden is not on the accused, the burden is on the state then to disprove that. So we would submit that, in fact, our relief does a better balancing of rights than the Act currently does. And it certainly doesn't place an undue burden on an accused in the situation. The core thing here is the effect of this provision. And I accept your comments on the provision completely, Justice Rogers. It does criminalize unlawful conduct, but the effect of this results in the infringements of the rights. And we can see that through Miss Holtztrager's case. If it didn't, then she would have had an acquittal in her case. She couldn't have.
Ms. Raja Bantland, I'm afraid I must confess that I don't see the way the case it is. Let me put it up front, and then you can tell me if you associate with my views or you don't. As I see it, what prompted this case is a number of acquittals, a number of reports that have been made where women have been sexually violated, and to put it more bluntly, with impunity. The situation that we have in our country now is daily and routinely women are violated. And we don't seem, the law, when I say we, I say the law does not seem to be coming to their aid. You have proposed a reading in. I just want to take you through what that reading in would envisage, and vis-a-vis the definition itself. Would it be appropriate to read, as in section 3, rape, I'm going to give you two formulations.
Okay.
One where there is no consent, and one where there is consent. Rape, any person who unlawfully and intentionally commits an act of sexual penetration with the complainant without the consent of B is guilty of the crime of rape. And then we would add, it is not a valid defense for that accused person to rely on a subjective belief that the complainant was consenting to the conduct in question. Then that's where the problem comes. Unless the accused took objectively reasonable step to ascertain that the complainant consented to the sexual act in question. This is how you propose the offense must read. Am I correct?
Yes, just not all in the same section, but yes, that is in substance is what we propose.
That's the substance.
Yeah.
My brother Musi took you through the subjective test and the objective indicia or facts that make the subjective test. If you go back to the definition as it stands previously, it is your client's case that it does not necessarily come to their assistance, because the perpetrators or the offenders would bring up the subjective belief thing. But you say, to guard against that, the caveat would be, you ought to have taken reasonable steps. My problem is, with that definition of an offense, you would have an offense that talks about the subjective intent as well as the objective intent. And you and I know that the two does not exist or coexist together. And this is what you are urging the court to put before Parliament to legislate on this. Remember, we cannot legislate. We can only say these are the inadequacies. I have at the back of my mind, which I have started to say, I'm aware and acutely aware that something needs to be done to safeguard the rights of women. How do we navigate the two? And then if you look at also the same definition, there is a proposition that we remove the consent part. And then if we remove the consent part, would you still need to have the remedy that has been proposed? Just have a look at it, because it will say a person who unlawfully and intentionally commits an act of sexual penetration with the complainant is guilty of the crime of rape.
Yes.
And the whole debate that we have where we want to bring in the subjective and the intent and the negligent test would go away.
Yes.
Bajat, I propose that you respond after the tea break. We've gone way beyond our tea break. Let's adjourn for 20 minutes.
Thank you.
You may respond, Mr. Butler.
Thank you, Justice Mhlantla. Justice Mhlantla, let me try to answer Justice Matopo's questions as best I can. Justice Matopo, you put to me a formulation of Section 3 that effectively removed consent. What we would end up with is the following. We'd effectively have a crime that resulted in unlawful and intentional penetration of a person without consent being an element. We would submit that that's not a solution in this case, because the effect of that is that you would still have to deal with the unlawfulness. And what would be unlawful here? You'd have a legality problem. You'd also have an issue that you'd actually get back to consent, because to determine unlawfulness, you'd have to work out that she consented or didn't consent. So we think that formulation may well create a host of other issues. In addition to that, the Law Reform Commission has, over years, considered the different methods of formulation, and the fact that it has taken so many years in different formulations shows us the difficulty of this problem. It's certainly not an easy case. But the Law Reform Commission and ultimately the legislature specifically adopted the modality of using consent and intention. So we would submit this court should not be looking at a formulation that removes those things. Really the nub of our case is that what we call the Amos defense, and that is the defense that says that you can have an unreasonable belief in consent. The nub of our case is that Amos defense is valid under our law, and that's unconstitutional. We know it's valid because Toko in the SCA says so specifically at paragraph 62. In Vilakazi in the SCA, there is a similar suggestion, and that's at paragraphs 47 and 48. So, and that deals with knowledge of unlawfulness. So we know that the defense that exists currently in the law as it stands says that if you have an unreasonable belief in consent, that's valid. So we are here asking this court to declare that defense unconstitutional. That's in essence if we come down to it. And we say that it must be unconstitutional because the effect is to make it incumbent on the complainant. If you allow that defense to stand, then it makes it incumbent on the complainant to physically resist, to create all of those objective factors that Toko took into account, or that was taken into account by the SCA in Toko, to show that she didn't consent. So, or to get, in that case, to Dolus eventualis. But it creates a situation, not just when it places this burden on a complainant to physically resist, to scream, to shout in circumstances where that might result in her life being threatened, but it also tells boys and men not to ask, not to do anything to determine whether there is consent. So it enforces this idea that if you don't subjectively know she's not consenting, it's better. So don't ask, don't check, right? Justice Rogers referred to civil remedies as a possible, of course there's civil remedies, but what we're dealing here with is criminal sanction for a heinous crime. So we would submit that while they exist, that's a different question. If Amos is expressly abolished, if that Amos defense, as we call it, is expressly abolished, or let me say it this way, the Act already does this.
Just interrupt.
Yes.
On the Amos defense. Amos is a defense in relation to the second applicant, am I correct?
In relation to the second applicant's case, yes.
Yeah, second applicant. If one were to say, look at the circumstances under which the second applicant went to the house of Amos, she went there under false pretenses. There's a party, you get there, there's nothing of the sort, and then she's given something which is mixed. Don't you think, one, those false pretenses, two, what she was given, would probably may have drugged her? into submission could have been the factors that the magistrate ought to have taken into account to say there was lack of consent. Because she didn't go there for that particular purpose. She went there because she was invited to attend the party. And lo and behold, when she gets there, here is the offender alone. And the offender makes her to be comfortable. As it good manners everywhere, she's offered a drink. Probably the drink was laced. And I'm just wondering whether, if we are to adopt the remedy that you're proposing, whether it will take care of the Amos defense, because if you are invited under false pretenses, and if your drink is laced, you would still have those problems. And take Coco as well. The fact that the High Court got it wrong, and the fact that it got it wrong does not mean that, as I look at it, the law has to change. The SCA changed the law, interpreted the law, made it very known and clear that if a woman says no, it's no. And if a woman says, I did not come to your house for that particular purpose, men or partners must respect that choice. So, can't we say that the law has now crystallized insofar as that is concerned? One, SCA has definitively spoken, and that addresses the Amos defense as well, because there is no consent.
And Justice Matopo, let me start with your latter point. The law has not crystallized sufficiently. The fact that that Coco was decided in the SCA as it was is positive and it's to be welcomed. But it deals with very specific facts. It deals with a situation in which the woman was able to say no, in which she was able to indicate that she wasn't consenting. In Miss Holtztrager's case, she wasn't. In cases where victims freeze, where they're unable to show consent, or where they are mentally incapacitated or mentally disabled, but the accused doesn't know that, the act still permits the act. So, the sexual act. So our law doesn't sufficiently deal with cases. Coco is not enough. It's excellent, but it is not enough. And the fact that it's not enough is shown through the facts of Ms. Holtztrager's case. Objectively, if we go back to your first point, Justice Matopo, yes, she was given a drink. We debated this in the High Court, in fact, as well, but there was no evidence that she was in fact drugged. Her evidence herself was that she was there voluntarily. She remained there when there was no party. She was okay to kiss him. She didn't object to that. What she objected to was the rape. And she didn't verbalize that objection in a way that was evidentially sound. She says she tried to say no, but she wasn't sure that he heard it. So those facts tell you that the law as it stands doesn't go far enough, and it wouldn't, and we can go round and round in circles, but this is not a case about what the magistrate should have decided. It's not that. This is a case about what the magistrate says she understood the law to be, which we say is not unique to her, and that application of the law is unconstitutional. So the Amos defense of allowing a man to say subjectively, I thought she consented, I didn't have to do anything more, so I had an unreasonable belief in consent, that's okay. Coco says that that's valid. Vilakazi says that's valid. So we submit that this court must make clear that that's not valid. That's where our case sits. My junior points out to me that actually what we're calling the Amos defense here is not just unique to South Africa. In the UK, it was called the Morgan defense. So it is, I'd mentioned previously that our statute as it currently stands reflects how the statute stood in Canada and the UK and New Zealand before the amendment to include the reasonable steps and reasonableness standards. But yes, I just make that point.
You don't have a problem with the negligence and the subjective tests coexisting in the formulation?
Yes, thank you for reminding me of that, Justice Matopo. I wanted to point you in that regard to Section 56. The Act already does so, and the foreign jurisdictions also do so, where they combine, as you put it, Justice Matopo, the subjective and objective factors. If one looks at Section 56(2)(a), it provides whenever an accused person is charged with an offence under Section 15 or 16, it is subject to Section 3 a valid defence to such a charge to contend that the child deceived the accused into believing that he or she was 16 years or older at the time of the alleged commission of the offence, and that the accused person reasonably believed that the child was 16 years or older. So what this is referring to is a subjective reasonable belief. And that we would submit also combines those tests. It is, it's not an elegant way of dealing with this. It does, sort of make the mind do some twists and turns, but the legislature thought that that was an appropriate way to deal with it. So what we're suggesting is not so out of the ordinary that, that it couldn't be included in this statute.
Thank you.
Thank you, Justice Matopo.
Thank you, Ms. Rajab Badlander. I think we can start from a sort of shared view around the problems around the prosecution of rapes in this country, the very significant and unacceptable levels of the crime and the very poor prosecution levels, poor investigation, and often poor treatment of the facts by presiding officers in lower courts, and the failure of the state, often given its limitations to appeal, under the Criminal Procedure Act, and its failure anyway to, as we can see in the current case, not to engage meaningfully on the merits of this matter, to in fact appeal against these decisions. So I think we can agree that there's a problem. And I think also there's a problem, it seems to me, that there are circumstances in which we can agree that those with less power or faced with risk or danger find it hard, if not impossible, to speak out in certain circumstances, and that risks and does create, and often in the current case, some very, very fundamental violations of rights. So if we move from that basis, that we need to have greater prosecution, need to have presiding officers dealing with the facts better, if we accept that there are circumstances like which occurred in your case, in which we have people faced with difficulties where there wasn't the evidence led as to why there was silence, in circumstances where, as Judge Musi has raised, that if it had been put to the court that she had kept silent under these circumstances, it may have allowed for a different outcome. My question within that background then is, and given the difference of opinion that exists between the amici and the parties before this court, whether the Women's Legal Centre's proposal or the trust proposal, that in fact we should leave this as an issue to be dealt with by the legislature and not engage as the court in trying to unravel what are quite complicated at this stage decisions, as has been debated with all of my colleagues, and say that if there is a problem, it's one to be raised with the legislature, that it would be on the Women's Legal Centre's version, it's that there's a lack of clarity as what would amount to objectively reasonable steps, that the reading in would place a burden that hasn't been foreseen in terms of what it would do to prosecution and to the accused, what steps the state would have to take to actually prove the case. And then thirdly, that the reasonable steps would be weaponized under certain circumstances. It seems to me that there are so many different views in the matter. Is it not one that should properly go back to the legislature? Because after all, the legislature is the body that is supposed to deal with the different views of our society and try and come to solutions as to how they would be resolved. In the sense that should the entire issue not be one that is dealt with not here by this court, we shouldn't be making solutions at this stage, coming up with something.
Savage, let me say this. I think it would do a fundamental injustice, not just to Miss Holtztrager, but to many other women that are currently before our courts in similar situations, for this matter to have come all the way to this court, only to be told that it's too complicated and there are too many different ways in which it can be solved for this court to solve that problem. specifically in the context where we say there is a blatant unconstitutionality. So if this court was to find that there isn't an unconstitutionality, that's a different situation, in which case I would submit that, that Justice Savage, you are correct. But in this case, we say there is an unconstitutionality. There have been rights infringed here. And this court has to deal with it. It is difficult. There are multiple remedies that may work to fix the problem. That has never been a reason for this court not to propose an interim reading in. It's not to say that the legislature will adopt that interim reading in, and that's why we ask for the period of suspension. The reason we adopt the interim reading in is simply to provide some relief in this interim period, because we know that even though we asked for 12 months, the minister has now come back and I think asked for 36 months. That is a long period of time for an ongoing constitutional violation to be allowed to persist. So we would submit that it is the job of this court to make a finding in this case and to attempt to fix that, well, to find that there's an invalidity and to attempt to fix that as best that it can. But it is ultimately, correctly, up to the legislature. That is why we don't agree with the CAL's position, for example, because we say the CAL's position asks this court to impose the coercive measures requirement in a way that is nowhere foreshadowed in the legislation. It may well be a very valid policy choice, but it's asking this court to go too far, which is, I think, what you are suggesting, Justice Savage, that really would be asking the court to do too much. And we oppose that. The WLC position, we say, is wrong, actually. We say it's wrong because WLC says that on the facts of Ms. Holtztrager's case, the court should have found there was Dolus eventualis. And that the problem in Ms. Holtztrager's case was that the court applied the facts wrong, that there are societal issues that are at play here, that prosecutions are done improperly. All of those things are what resulted in this, and actually she should have appealed and it may have been fixed with Dolus eventualis, as happened in Toko. But we've shown, and I've referred to that earlier today, that doesn't answer. This case, the facts of this case does not meet Dolus eventualis. There is no way in which you could have used Dolus eventualis to fix the problem of the subjective intention. So the WLC's position is premised on the Magistrates' Court being wrong. The Minister's position is more closely related, I think, to your question, which is leave it alone. It is sufficient. But that will not result in amendment to the statute necessarily. It will leave it alone. It will let the statute stand as it is, and hopefully the legislature at some point decides to take these concerns into account in amending the statute. We know already that the legislature has amended the statute several times in a valid attempt to try and meet the concerns. We're not suggesting that government hasn't tried to fix the problem, and we recognize that the problem is immense. But what we're placing before this court is one aspect of the problem and one way in which to fix that problem.
Ms. Raja Butlander, my question also focuses on Dolus eventualis. Now, let me just reiterate that I have the same pressing difficulties with trying to sort this serious societal problem through intervention by courts, and particularly this court. It just seems to me the Law Reform Commission was making good progress to where you would want them to be, but nothing's come of it. Also concerned about what rights are being infringed here. But when the Women's Legal Center say that any belief by an accused person regarding consent, no matter how unreasonable, it's not correct to say that that is sufficient to establish intention. And they talk about Dolus eventualis. Now, I understand you differentiate between Dolus eventualis and the question regarding consent and regarding intention. But I would have thought that after the SCA decisions in Humphreys and Pistorius, that how Dolus eventualis is to be applied in practice is very clear. What do you say, why is the application of Dolus eventualis generally? Do you say it's not a solution or a partial solution? Or do you say it isn't a solution in Ms. Holtztrager's case?
Yes, thank you, Justice Majid. We say it is sometimes a solution. Absolutely. It resulted in a positive outcome in the Koko matter. But it would not have been a solution on the facts of Miss Holtztrager's case, because there was no way to show the subjective element of dolus eventualis. The reason that I say that there is misunderstanding of dolus eventualis, I think you're absolutely right. Humphreys is clear, Pistorius is clear, and those are good judgments. But what we're seeing, just even in the WLC's intervention in this case and how they think dolus should have been applied on the facts of Ms. Holtztrager's case, is yet again a misunderstanding. I think partly that misunderstanding comes in from the importation of objective factors to determine subjective consent. And what sometimes happens is that that gets interpreted to mean that the intention then of foreseeability is actually objective. But it's not. Our courts have said very clearly it's subjective. So there is that remaining misunderstanding. It may be that that's not necessarily something we're asking this court to fix. I simply point it out because I think it is a subject that seems pretty vexed in how practitioners and courts seem to deal with it, despite, as you point out, Justice Majid, our courts have been fairly clear, I would have thought.
Lastly, I hope this doesn't come across as a sexist remark, but we've sat in courts many times. We've defended people for rape as counsel, sat in courts many times. And it is a truth that sometimes rape is being weaponized by victims or alleged victims. One's got to be very careful in these kind of cases that as much sympathy as you may have for the problem in our country, which is a very severe problem, that one doesn't throw the baby out with the bathwater. I understand your concern, but it seems to me a lot more work has to be done by people like the Law Reform Commission and parties like these before us would make inputs in that process for Parliament to make an informed decision about all of this. Because you've got to balance these things, and that's what worries me about this consent problem.
Yes, Justice Majid, I think that's correct. A lot more work must be done. I think there are obviously going to be cases of a false accusation of rape. But the relief that we seek, number one, we know in the context of the statistics around GBV in this country that those false allegations are few and far between, but they exist. Our laws, it is incumbent on us and on our laws to balance the rights and interests of both parties in this. And we submit that currently, I've said already, that it's not balanced. But law reform, as valid and important a process it is, takes years. If one looks at how long it took simply to get to this formulation, it's many, many years. I think it began in the early 2000s. I stand to be corrected, but I think that's when this particular formulation began to be conceived, where consent was considered, and where even the formulation we suggest was considered, where coercion was considered. All of these things were considered before it found its way through to the statute. So yes, it's an important process, but in the context of an unconstitutionality that we submit exists, we can't simply wait for that process to run. I've said earlier today that I think this is a multifaceted process and that the court's job here is one part of that. It does not release or preclude an obligation on civil society, on our NGOs, on our government to take steps in relation to all of the other factors that contribute to the scourge.
I'm sure we'll, if not I, but some of my colleagues will ask the Minister's Council about the peculiar way of litigating in this case, but I see that in their written submissions filed on the 22nd of September, they say that, and I need you to respond to this, they say there's no justification for your claims except that it is, and I'm reading, it's not me saying this, a desperate attempt to unreasonably mulct the respondents in costs, because they've explicitly said they abide the decision of this court. They've come to court with an explanatory affidavit, and then they cite Matatiel and they cite Kosa and Minister of Social Development, that the minister shouldn't, based on those decisions, the minister shouldn't pay the cost. And in all fairness, I just want your response to those submissions, please.
Yes, thank you for giving me that opportunity, Justice Majid. Our position is this. There is a responsibility on the minister responsible for a statute that is constitutionally challenged to come before this court to assist the court with its understanding of the statute, with things such as how long it will take to amend if there's a finding of unconstitutionality, with legislative reform, with all those things that may assist in any particular case, and that's not an exhaustive list. It is not the obligation of the minister to say that the minister is abiding the decision of this court, and then come to court almost a year later and say, and put up a substantive opposition to the relief sought, which is what we actually see. What we see is, I've pointed it out, the inclusion of an argument on the right to silence that did not exist in the High Court. So it's making, it's raising all sorts of new issues that we know should not be raised at this stage. That is prejudicial to us. We had, with the grace of this court, a few days to respond to that as best that we could. But we didn't have the High Court didn't have a position to think about those things and to afford this court the benefit of its thinkings on that subject. So that is a fundamental problem. The minister, in its response to our submissions, I think may have misunderstood what we were saying. But I'm going to leave that aside. Pertinently, the issue of costs is something that they raise, and you've referred to, Justice Majid. We're accused of trying to opportunistically mulct the minister in costs, where they simply come and seek condemnation. That's not true. Number one, we only seek costs for the confirmation. We seek it as a sanction for this kind of behavior from a minister. This is not a case of the minister abiding. The minister in this case actually abided from early on, but didn't file an affidavit. And so all of us in this matter proceeded on the basis that the minister was not going to file anything in this matter until last week. So that is why we seek costs, not for anything else. And just to be absolutely clear, I don't make any aspersions on the professionalism or abilities of my colleagues. This is not about the quality of the submissions or anything like that. What we see in the condemnation application is a process that the minister should be embarrassed to place before this court, quite frankly. There's a process that took, where his counsel or her counsel sent numerous drafts of affidavits that took months and months to vet and sign. That is unacceptable where there's pending litigation for the highest court.
May also be because of the change of ministers that we know of.
That may have been, but this minister has been in office now for some time. And the truth is that it has literally been the better part of the year. And we would submit that that's not, that is something worth sanction. But yeah, those are our submissions.
Rajab Patlender.
Thank you, Justice Platter and Justices.
Now it's Mixed Mokhoranyan. Vocals. You have your 3 minutes uninterrupted time.
Justices of the Court, I shall address the following topics. First, jurisdiction for leave to appeal. Second, CAL's grounds of appeal. Third, remedy. This matter comes before this court as a confirmation proceedings in terms of section 175.5, read with 172.2 of the Constitution. This court has exclusive jurisdiction to confirm a court's quote-unquote declaration of constitutional invalidity of the impugned provisions. Thus, this matter does engage the supervisory jurisdiction of this court in respect of the declaration of invalidity. In addition, this Honourable Court also has jurisdiction over this appeal in terms of Section 172(2)(d) of the Constitution. This matter raises critical questions concerning the constitutional rights of equality and dignity, among others. Thereby squarely engaging this court's jurisdiction, CAL submits that the interests of justice are pertinent here and that the imperative for legal certainty demands the constitutionality of the impugned provision to be decisively resolved. I'll start with CAL's grounds of appeal. The first ground of appeal is failure to consider CAL's pleaded case under Section 172 of the Constitution. CAL's case before the High Court was a frontal challenge to the impugned provision. This can be seen from Record, Volume 3, at page 230. In paragraph 20 of the Court of Quo, the court only summarizes CAL's case. This is paragraph 22 and 23, which can be found at Volume 1 at page 370. The High Court only says at paragraph 36 of its judgments that CAL's submissions are logical and therefore they're understandable. But the High Court then says they're not sustainable due to the fact that consent in the definition of rape and other offenses is included as a policy decision by the South African Parliament. This is at Volume 1, page 56. This court in Vodacom versus Makate and others recently was talking about assessment of a case and held. It is about a substance of a judgment viewed holistically. So viewed, does the judgment tell a reasonable, if not discerning reader, that there was compliance with the duty of proper consideration? In this regard, is it enough if the judgment clarifies the issues that were vital to the determination of the matter and then show why they were determined? Justices, the Court of Quo does not deal with the issues that CAL's placed before it. I submit that at para 30 of the judgment, which can be found on page 40, Volume 1 of the record, the judge says, the issues for determination are whether sections 3, 5, 6, 7, 8, 9, 10, and 11 cap A, read with 1, 2 of the Act, are constitutionally invalid in permitting a defense of subjective through unreasonable belief that a victim consented to the sexual act. And 2, whether the limitation of these rights is reasonable and justifiable in an open democracy based on human dignity, equality, freedom, in accordance with Section 36. It can be seen from that paragraph 30, the Court of Quo has not dealt with the issues that CAS placed before it. I submit the Court of Quo did not comply with the duty of proper consideration. As this court has said, a court will have failed in its constitutional duty to give a proper case consideration and to give reasons for its decision if the court's judgment does not contain adequate reasoning evidenced. And as I've just illustrated, in paragraph 30, it seeks that the court only seeks to deal with issues for determination as issues that the embrace applicant placed before it and not the applicants of CALS. The first ground of appeal I move to is, does consent as a definitional element of the impugned provision violate Section 9 of the Constitution? Justice Matopo has said in Shabalala, for far too long, rape has been used as a tool to relegate the women of this country to second-class citizens over whom men exercise their power and control, and in doing so strip them of their rights to equality, human dignity, and bodily freedom. Substantive equality requires an examination of the structures, context, and impact of a law on disadvantaged groups. It recognizes that laws which appear neutral on their face may perpetuate systemic inequality. In the context of sexual violence, substantive equality underscores the importance of a holistic approach that acknowledges the unique vulnerabilities and experiences of survivors. It advocates for a shift towards victim-centered approaches that considers the social, psychological, and systemic factors contributing to sexual violence. While the impugned provision may, on the face, appear neutral, their impact is not. They operate in a context where women and gender-diverse persons are disproportionately affected by sexual offenses. The inclusion of consent as a definitional element of rape raises significant constitutional concerns, particularly in relation to Section 9 of the Constitution, which guarantees equality and prohibits unfair discrimination. 1, how does the inclusion of consent equality. It places an unequal burden on victims. The retention of consent as a definitional element means that the prosecution must prove that the victim did not consent. This places a disproportionate burden on victims, especially women, children, and other vulnerable groups, who may not be able to demonstrate non-consent due to a number of reasons. And the amici, the first and the second amici, have already spoken or will speak about peritraumatic responses. The first and the second amici will enlighten this court about the peritraumatic responses and the broader psychological argument. As a result, not all victims have equal protection before the law. The second, it perpetuates discrimination. Historically, proof of consent has reinforced harmful stereotypes, such as victim blaming, and has made it hard for certain groups to access justice. This approach perpetuates discrimination against those who are already marginalized, undermining their constitutional promise for substantive equality. Third, denial of equal protection and benefit of the law. Section 9 requires that everyone receives equal protection of the law. If the law structure makes it harder for some victims to achieve justice because they cannot prove non-consent, then the law is not providing equal protection or benefit. This is especially problematic in cases that involves power imbalances, relationships of authority, and situations where the victim is incapacitated. Fourth, failure to recognize the societal realities. The requirement to prove non-consent ignores the social and psychological realities of sexual violence, such as trauma responses, and the complexities of coercion and manipulation. This can result in unequal outcomes. By focusing on the absence of consent, the law places undue emphasis on the behavior or credibility of the complainant rather than the actions of the accused. This can lead to secondary victimization, where survivors are subjected to invasive questionings and scrutiny, underlying their dignity, equality, and freedom before the law. Words matter. Words give a construction of a certain viewpoint of the world, and the viewpoint tends to be gendered. That was Justice Rampepe in the Shabalala case at paragraph 70. There is a distinction between gendered crimes and non-gendered crimes. In the case of non-gendered crimes like assault or robbery, the focus is generally on the actions of the perpetrator. Less scrutiny is placed on the behavior or the credibility of the victim. However, in gendered crimes, particularly sexual assaults, the emphasis often shifts to the victim's actions, choices, and credibility. This disparages, perpetuates harmful stereotypes, and reinforces systemic biases disproportionately affecting women and other marginalized groups. This distinction undermines the constitutional guarantee of equality under Section 9. Victims of sexual assault are subjected to additional hurdles in seeking justice, including invasive questioning and societal judgment, which are not typically faced by victims of non-gendered crimes. Such treatment not only violates their dignity, but also perpetuates unequal access to justice, further entrenching gender-based discrimination. CAL's expert, Professor Jamila, submits that, unlike other types of assault, such as common assault or other egregious types of assault, sexual assault is effectively deemed to be lawful but for lack of consent. This means that in sexual assault cases, the starting point is the conduct, i.e., sexual activity is lawful, unless the allegation is that it was without consent can be proven beyond a reasonable doubt. In other words, but for lack of consent, the conduct would be lawful. But the retention of consent as a definitional element is because of a misconception between rape and sex as two sides of the same coin, only divided by consent. Professor Jamila says at volume 6, page 565 at paragraph 22, it is, however, inappropriate to consider rape to be otherwise lawful sexual intercourse, rendered unlawful through lack of consent. Rape is forced or coerced sex, where coercion need not be direct, explicit, or through physical force. This unlawful conduct is therefore not consentless sex, but forced assault. This has also been supported by this court. In S versus Masia, the court emphasized the need to protect vulnerable groups and to interpret sexual offenses in a manner that advances equality and dignity in line with 9.1. In the Teddy Bear Clinic, this court emphasized that sexual offenses laws must not perpetuate discrimination or reinforce harmful stereotypes and must be interpreted to promote substantive equality. In Commercial, this court held that the state has a duty to protect the rights of women and children to equality and dignity and that the criminal justice system must not create barriers to justice for victims of sexual offense. Although any offense could theoretically include consent as a definitional element, in practice this feature appears exclusively in sexual offenses. This highlights the exceptional and problematic ways these crimes have historically been treated in criminal law. By maintaining this unequal framework, the law fails to provide equal protection and support for all victims, thereby reinforcing structural inequalities and undermining the principle of fairness and justice. By retaining consent as a definitional element, perpetuates the misconception that sexual assault is primarily sexual activity rather than violence or coercion. In Shabalala, Justice Rampepe at paragraph 70 has said, rape is often mischaracterized as an act of sexual intercourse absent consent committed by inhumane monsters. This is a dangerous mischaracterization of rape. Words matter. Although rape is defined as an unlawful and intentional act of sexual penetration by another without consent, it must be buttressed that the victim does not experience rape as being sexual at all. The requirement of sexual penetration is a legal requirement which relates to the biological element of sexual intercourse. For many victims of rape, they do not experience rape as a sexual encounter, but as a frightening, life-threatening attack. The approach to have consent retain hinders meaningful law reform by reinforcing outdated, sexualized narratives instead of recognizing these offenses as acts of violence and domination. CAL submits that crimes such as assault do not require the absence of consent to be proven. It is self-evident that an attack occurs without consent. The same principle should apply to sexual offenses. Removing consent as a definitional element would reframe these offenses as acts of violence rather than sexual acts, thereby desexualizing the crime and focusing on the accused's conduct. Victims are often required to prove detailed accounts of their resistance of lack of consent, subjecting them to invasive questioning and scrutiny. This process not only re-traumatizes victims, but also reinforces the societal narratives that women are partially responsible for the crimes committed against them. Women, often who are the primary victims of sexual assault, face systemic barriers that reflect and sustain patriarchal norms, further entrenching gender inequality. This approach stands stark in contrast to treatments of victims in non-gendered crimes, where the state has to prove beyond reasonable doubt the unlawfulness of the perpetrator's action and not the victim's behavior in order to avoid the harm. A shift in focus is necessary to ensure that the justice system prioritizes the accountability of perpetrators rather than placing undue pressure on the victims. Despite statutory reforms aimed at modernizing legal reform for sexual offenses, the justice system continues to perpetuate force-based reasoning. This is an outdated approach, prioritizing the presence or absence of physical force or resistance in determining the validity of a rape claim rather than focusing on lack of consent. Effectively, what consent does, it seeks to impute a force-based reasoning, because in order for a victim to say that they have lack of consent, they must have done something outrageous or outwardly so that the accused is able to know what happened. The second ground of appeal I deal with is that the High Court did not deal meaningfully with the evidence that we submitted on behalf of Professor Jamila. The evidence of Professor Jamila is at volume 6, pages 560 to 569. Professor Jamila's evidence was central to CAL's argument that retaining consent as a definitional element perpetuates discrimination and systemic inequality. Her testimony highlighted how this approach entrenches victim blaming by shifting the focus of the trial onto the complainant's conduct rather than the accused's culpability. The Court of Law failed to address these critical insights or explain why it rejected them as constituting a material misdirection. It demonstrates an absence of meaningful judicial engagement with expert evidence that directly has bearing on the constitutionality of these impugned provisions. The third is the failure to consider international and comparative law. This court recently in Jordan versus the Minister of Home Affairs said, when interpreting the Bill of Rights, a court is required in terms of Section 39(1) of the Constitution, to consider international law, and it may have regard to foreign law. In AK versus the Minister of Police, this court said, "It is tried that the duty to prohibit rape and other forms of gender-based violence is a customary norm of international law. South Africa is a party to several treaties which enshrine the rights of women. Chief amongst those is the Convention of the Elimination of All Discrimination Against Women and the Protocol to the African Charter of Women and People's Rights and the Rights of Women in Africa. Taken together, these instruments regard gender-based violence as a pernicious form of discrimination against women that undermines their rights to equality and sexual autonomy." International law has increasingly recognized the limitation of using consent as a definitional element. We referred in our heads of argument to the Roman Statute of the International Court to provide a notable example. It frames rape as an act of penetration committed under coercive circumstances, including force, threat, or abuse of authority. This approach moves away from a focus on consent and instead emphasizes on the context of the act, particularly the power dynamics and the coercive environment in which they occur. The international CEDAW has also called for legal definitions of rape to focus on the violation of sexual autonomy rather than requiring victims to prove non-consent. We've also referred in our heads of arguments to our neighboring countries that have moved away from consent to coercive circumstances, notably Namibia. Namibia has recently adopted a framework that emphasizes coercion and abuse of power. The Combating of Rape Law, which is a 2000 act, defines rape as any person who intentionally, under coercive circumstances, commits or continues to commit a sexual act or cause another person to commit a sexual act with the perpetrator that shall be guilty of the offense of rape. The same move was done in Eswatini, and the same move to coercive circumstances was also done in Lesotho. We asked the court to take that our neighboring countries and jurisdictions around have moved from consent, the removal of consent, and have opted as one alternative to include coercive circumstances. South Africa, therefore, has an opportunity to align with this progressive trajectory, ensuring that legal reforms better protect victims and advance gender equality. It is tried that once a law or provision of law have been declared invalid, the court has a range of options available at its disposal to remedy the invalidity. If the court, Section 1721B2, affords the court the power to temporarily suspend the effect of a declaration of invalidity, the purpose is to honor the separation of powers doctrine to mandate Parliament to correct the constitutional defect. And this has been seen in a number of cases. Yesterday, while preparing, I believe a stroke of genius struck me. And I thought, well, the court is going to ask me about remedy, and maybe that's where my problem is going to be, because as we've seen, the Embrace applicants have said we intrude on the separation of powers. And I said, okay, what can the court do? And I came to this, severance. Severance does not seem to infringe separation of powers to invalidate less rather than more of a statute. In Curiae versus the Government of the Republic of South Africa, the Constitutional Court laid a two-part test. The test is, first, is it possible to sever the invalid provisions? And second, if so, what remains give effect to the purpose of the legislature? I submit that this case is a good case for severance. The concept of consent is already captured in the elements of unlawfulness as discussed by my learned friend. The current definition is therefore redundant. The removal of consent stays true to the object of the Act. Section 2 deals with the objects of the Act, to afford complainants of sexual assault and maximize least traumatizing protection that the law can give, to introduce measures which seek to enable relevant organs of state to give full effect to the provisions of the Act, and to combat and ultimately eradicate the relative high incidence of sexual violence committed in South Africa by protecting complainants of sexual assault offenses and their families from secondary victimization and trauma by establishing a cooperative response between all government departments involved in implementing the effective responses and sensitive criminal justice related to sexual offenses, and also to give proper recognition to the needs of victims of sexual offenses through timeous, effective, and non-discriminatory investigation and prosecutions. I submit that removing consent is just like any other remedy. It is not a silver bullet, but its removal will have significant positive consequences on the law of sexual offenses and for survivors and complainants. Removing consent will also stay true to the principle of criminality by bringing our understanding of sexual offenses in line with how we understand in other interpersonal violence. It will also be protecting the complainants from an unjust burden to show what they did to communicate that they were not consenting in the moment of the offense. Removing consent also helps to ensure that there's no secondary victimization in the form of character assassination of the complainant after the fact. This may not wholly fix the problems, but it certainly goes a long way. By removing consent, sexual offenses will still require unlawful intentional conduct, and so the removal of consent does not change that. But what it does is to bring sexual offense in line with other offenses that require intentional unlawful conduct. The underlying unlawful conduct of rape is sexual violations. This court has said that rape is heinous. That is rooted in violence, in domination, and in power. Sex is not. What we would propose as a remedy in severance is Section 3 of the Act may read, as Justice Matopo had discussed with my learned colleague. Any person, A, who unlawfully and intentionally commits an act of sexual penetration with the complainant is guilty of the offense of rape. That is, removing the words without consent. The other alternative that we had was suspension and reading in. The interim reading in of coercive circumstances in place of without consent does not inherently breach the principle of separation of powers. Courts often use this approach to address unconstitutional gaps in the law. If we have regard to the definitional section of SOMA, we will look at consent, the definition of consent. Sorry, the internet is a little bit slow. The definition of consent says consent means voluntary or uncoerced agreement. So the idea of reading coercive circumstances into the definition is not playing with or changing the legislature's intent. This is already foreshadowed in the definition, that it says that circumstances in respect of which a person does not voluntarily consent are contemplated, and it says these are the following. So this idea of coercive circumstances is already foreshadowed. So removing without consent to include coercive circumstances is not an overbreach, but rather it is already foreshadowed in the legislation. But what it does do is that it moves the burden from the complainant to focus on what they did not do or what they did in order to say they're not consenting. I'd like to spend a couple of moments talking about the Embrace case. The remedy that Embrace seeks is an insertion of the definition that specifies that any defense to mistaken belief in consent must be reasonable and that the accused must show reasonable steps. By doing so, it adds significant objective elements to what is meant to be a subjective assessment of fault through intention. It also creates discrimination between other offenses for which the common law defense of mistaken belief in consent is available. So we're not clear if one is to raise mistaken belief. Is one raising mistaken belief under the common law, or is now one raising mistaken belief in terms of the legislation? It seems that the appropriate thing to do if the Embrace applicants had concerns is to challenge the constitutionality of mistaken belief under the common law, because it's a common law remedy. It also has the effect of infringing on the accused's rights to silence, in that the reasonable steps require the accused to testify. I submit that it not only requires the accused to testify, it creates an evidentiary burden that goes beyond an accused having to show their version is reasonably possibly true. It has to show steps. That evidentiary burden will now be placed on the accused. Further, the remedies will create inconsistencies between sexual offenses and other offenses, and the court is able to do that, but the court would have to explain. Importantly, it moves away from the subjective focus of intent in adding objective elements to the point where it's entering into a negligence offense and placing an evidentiary burden. In the heads of argument, they say negligence is blameworthy, and we agree with that. But the decision of whether to make rape a negligent crime, that is for the legislature. And therefore, that is why our remedy seems to be less intrusive than that of the embrace applicants. Those are one more. As Justice Matopo said in Shabalala, the scourge has reached alarming proportions in our country. Joint efforts by the court, society, and law enforcement agencies are required to curb this pandemic. This court would be failing in its duty if it does not send a clear and unequivocal pronouncement that the South African judiciary is committed to developing and implementing sound and robust legal principles that advance the fight against gender-based violence in order to safeguard the constitutional values of equality, human dignity, safety, and security. One such way in which we can do this is to dispose of the misguided and the misinformed view that rape is purely about sex. As the court has said, rape is about power and domination. Continue this misguided trajectory would implicate this court and other courts around the country in perpetuating of patriarchal and rape cultures. Those are submissions.
Thank you, Ms. Mogolane. I see you still have 2 minutes. Thank you.
Yeah.
Thank you, thank you. I just want to go back to your submissions. I'm not sure whether now you've no longer abandoned your initial relief, because initially what you sought was the replacement of the term or words without consent with coercive measures. Now you're talking of severance without anything being set in there. Is that what you're saying?
Thank you, Justice Nhlanhla. It won't appear from the High Court judgment because, as we've said, the High Court didn't deal with our case. But one of the alternatives we floated during discussions with the High Court was that we could just remove without consent if we feel that coercive circumstances, that reading in is an encroachment. But we know that remedy is for the court, and we're saying we can give the court a number of options, and ultimately the court can say which option would work for it. And in this case, to assuade the court of the fact that it's not breaching separation of powers, we would propose severance of the without consent.
My other question was going to be, consent is defined in section 1.2 as meaning voluntary and uncoerced agreement. And sub 3 lists all the circumstances where consent would not be a problem, like the person who's asleep, unconscious, all of those are listed. Now, I'd like to just explain to me what is the difference. If the Act specifically states this, why would you then say this must be changed, and what is wrong with what is contained in the Act?
Justice, thank you for that. Consent is defined as voluntary or uncoerced agreement. The submissions that will be made by the first and the second amici will speak about peritraumatic responses. In some ways, the circumstances in sub 3 don't completely do away with the problem. And we say that if you remove consent from the definition of rape and other sexual offenses, that undue burden that has been placed on the complainant through the burden to prove beyond reasonable doubt will be taken away. And that's why we're saying severance, or if not, for the interim reading in of coercive circumstances, because words matter. It's important. Without consent does seem to place a burden on the person who was not consenting to prove that they weren't consenting. But what coercive circumstances does in the definition, if we were to go with that approach, is coercive circumstances focuses on the surrounding circumstances in which the act of violation took place. So it is less concerned with the credibility, the behavior of the victim, but rather about the circumstances in which the rape took place.
your argument will cover all the provisions from section 3 to section 11, capital A.
Yes, Justice Mhlantla, we would remove without consent in those sections.
Section 11, capital A, that's the one that deals with harmful disclosure of pornography. If you remove consent there, how is it going to be dealt with that particular provision?
Capital A still says a person who unlawfully and intentionally discloses the disclosure of pornography in a manner takes it without the consent. So the unlawful and intentional would still be elements of the crime, but you would remove without consent again to remove the burden from the complainant to prove that they did not acquiesce to the harmful disclosure of pornography.
If absence of coercive circumstances and absence of consent, what is remaining for the
Absence of? Justice, unlawfulness is still left. And as we understand unlawfulness in criminal law is we have to prove that the act is not unlawful. So the unlawfulness will capture a number of instances, whether there was coerciveness, whether there was fraud, misrepresentation. So the idea is that the burden will be taken away from the victims because that burden is not placed in non-gendered crimes. So an assault, you don't have the burden to prove without consent. But as Snyman has said in his book, which I'm happy to read to the justices who so required, Professor Snyman says that consent could be a defense for assault. He makes examples of if you go to, if you play contact sports, for instance, you could say you're consenting in that regard to be injured. And also if you go to a hospital facility, for instance, and there's a botched surgery, but you consented, consent could still be a ground of justification.
Parliament deliberately chose the consent-based framework after the Law Reform Commission consultation. Why should we as a court interfere with that?
Justice, I think the yardstick of constitutional invalidity is applicants must come to this court to prove that something, a law or a conduct is inconsistent with the Constitution. As I've outlined in my submissions, we've said that the inclusion of consent unlawfully infringes on the rights of equality. If the court accepts that the rights of equality have been infringed, there's no limitations that's been justified, the court must, in terms of 172, declare the section unconstitutional to the extent of its inconsistency. And the court must then propose a remedy. And we're saying one remedy is severance, and you could take it back to Parliament and say, Parliament, you have 18 months to fix this. But we're saying the severance, what it does, the removal without consent, is that it doesn't encroach particularly on separation of powers. It just removes the bad from the good, because the good will still be intentional and unlawful conduct. So we're not asking the court to do the work of Parliament, so to say.
Mayor Mahorane?
In trying to persuade us that we should move away from consent, one of the criticisms is that the victim will be the one who has to prove that there was no consent, and that the victim will have to relive what happened. I'm wondering whether, if we adopt coercive circumstances, the victim will also not be subjected to that, in the sense that the victim will then be asked to explain, and there might be a dispute between their victim and the complaint and the perpetrator as to whether those circumstances were coercive or not. So I'm simply trying to check with you whether my thinking is correct in thinking that this may not be a solution, because the victim will still be subjected to that.
Thank you for,
Instead of justifying consent, the victim will have to justify coercive, whether there were coercive circumstances or not.
thank you, Justice Chikli, for that. I think this is also one of the difficulties I had in preparing, that perhaps coercive circumstances or measures would not be fix the entire problem, and that's why I propose severance to remove without consent, because that would take the victim would not have to speak about coercive circumstances. But Justice Chikli, I also wanted to say that the definitions, at least from Lesotho, Namibia, and Eswatini, is quite expansive to show what coercive circumstances would be. And in the Act, it says, it speaks about use of force or intimidation where there is an abuse of power, where there was false pretenses. I think that that's a lesser burden to a complainant having to prove what they did in order to show the other person that they were consenting. It seems it would be a little bit of a less burden to prove that there was false pretenses. Let's take the second applicant in the embrace challenges. There were false pretenses in relation to why she was meeting the person. It was said to be a party. And when she got that, there wasn't party. So those false pretenses seem to be a little bit better to prove than to prove what they did not do or what they said or did not say in order to not be seen as consenting.
No, I hear that, but in the same case, if Miss Holtztrager said, well, I was misled into going there, then the perpetrator says, well, yes, I misled her, but when she got there, everything else proceeded voluntarily.
Justice Chikli, I think, if my understanding is
I'm still looking at
coercive circumstances, yes.
If the perpetrator says that, well, there were no coercive circumstances, all that happened is that I misled her into coming to my house. But after that, everything proceeded with permission or with consent or voluntarily or without coercion.
It does appear that false pretenses or false fraudulent means would be, we would look at where the commission began to take place, and in our submissions it would be the mere fact of false pretenses already shows that there is an element of power or coercion. So anything that would happen after that would not necessarily be within the definition of voluntary and uncoerced agreement.
Okay. Now let's move to unlawfulness. Will unlawfulness be interpreted in the same way in all these several circumstances from Section 3 and the others, all the sexual offenses?
Yes, Justice Chikli, all the offenses start by saying that, for instance, if I read Section 5.
What I'm trying to clarify to my mind is whether, yes, unlawful is already there, but if the focus or the way in which to interpret the statute is now focused on unlawfulness. Because remember, you said that it could be, without consent could be dispensed with. If now what remains is unlawfulness, are you submitting that it will be interpreted the same way in all the sections?
Yes, Justice Chikli. So all the sections speak about unlawful and intentional commits an act of sexual penetration. So from sections 3, 4, 5, 6, 7, 8, 9, until then, it would read the same thing. So the assessment of unlawfulness.
The reading I understand, yes, you read whatever it is there, but when it comes to the court then deciding what unlawfulness means in that circumstance or context, does it apply the same way?
Yes, it would apply the same way in terms of how unlawfulness applies in broader criminal law. So the court will look at the unlawfulness in that context. And that's why our submission is it would bring sexual offenses to the realm of criminality rather than sex gone wrong.
Let's take an example. in order to clarify it. For instance, in rape, what would be unlawfulness be as a result of? What would the state have to prove?
The state would have to prove that the rape happened in a particular way, so it could either be coercive, fraud, it could be a number of things that underpin the unlawfulness. And in that regard, that's what the state would prove, that this wasn't sex, but it was rape, it was a violation of someone's personal autonomy or sexual autonomy. So that's what the state would prove.
And it would not be necessary to invoke without consent.
It would not be necessary to invoke without consent, because right now, Justice Chikwi, what we have is the state has to prove without consent because it's a definitional element, and they have to prove it without reasonable doubt. If that is removed from the legislation, the state would look at how it can prove unlawfulness, and consent may not necessarily be one of the ways in which they prove or lack thereof.
Thank you.
Thank you, Justice Chikwi.
I just want to pick up on your debate, because if you remove without consent, then the definition says a person who unlawfully and intentionally commits an act of sexual penetration is guilty of an offense. Now, acts of sexual penetration are committed all the time by consenting people. So what guidance would law give with regard to what would constitute unlawfulness? It would seem to me that the consideration of consent, and I take your criticisms of it, at least provide some guidance with regard to what would constitute well, not an intentional act, because we know that, but what would constitute an unlawful act. Because then we'd be in the realm of total uncertainty as to, and the law is supposed to provide guidance with regard to how we regulate behavior and conduct.
Thank you so much for that, Justice Colopin. In truth, without consent in the definition is a redundancy. We know that unlawfulness speaks to, is there a ground of justification in order to make
Sorry, did you say without consent the definition is redundant?
No, with consent right now, the definition is redundant, because what it does is that it creates a double burden. You have to prove unlawfulness. Unlawfulness speaks about, is there a ground of justification to make this act that is prima facie unlawful lawful? And then it says, in addition to that, you also have to prove without consent. So removing without consent would not create uncertainty, because we know in the criminal law, lawfulness or unlawfulness speaks about the fact that there isn't a ground of justification. For all the ground of justification, maybe it could be different grounds of justification. It could be necessity, private defense. It could be whatever it is. But in criminal law, we know that unlawfulness is not uncertain or doesn't create uncertainty, because it already tells us that here in this case, it says, if a person who intentionally and unlawfully penetrates someone, they're guilty of an offense. That's prima facie. Then what that does is that the state must prove beyond reasonable doubt unlawfulness and consent. And as I've discussed with Justice Chikwi,
What would distinguish a lawful from an unlawful act of penetration? One of those factors would be consent.
One of the factors may be consent. Yes. But as I've also transversed with Justice Chikwi, it could be a number of other coercive circumstances that negate the lawfulness of the act, so to say. Because it is really important, Justice Colopin, for us to know that rape is not sex gone wrong. Rape, as this court has said, is about power.
I accept that. I'm just trying to get to the crux of your argument. And
yes.
My second point is really around whether it's absence of consent or duress or whatever. It seems to me that the tenor of the discourse is when we use terms like compulsion and coercive circumstances. What we're really saying is that they operate to negative, free, and voluntary consent. That's their effect. And that's what you almost said now in your argument.
Yes.
And so, isn't this just a roundabout way of trying to excise and sever consent, but invariably you come back to it? And you come back to the same evidentiary problems the same scripts, the same myths that bedevil the whole question of consent. It's just a new form of words, but the problem persists because ultimately you want to get away from consent. But the whole discussion on coercive circumstances and the rest of them all seem to gravitate back to whether these were willing participants in every sense of the word. And if one was unwilling, it would have been an unwillingness based on an absence of consent.
Thank you, Justice Colopin. I just need a moment to think about this. Please give me a moment. Thank you, Justice Colopin. Right now, we understand that what the state must do is that it must prove consent beyond reasonable doubt or lack of consent beyond reasonable doubt, which means in many instances the complainant is cross-examined and their credibility is put on trial. What we propose in the removal of consent is that the state will have to prove the penetration and, let's call it, the coercive circumstances. If the accused is so inclined, if they are to take the stand to raise consent, then they would bear, as in any other crimes, prove that evidentiary burden that the person has consent. What we're trying to do here, and Justice Colopin, you may be correct that it invariably brings consent in another way, but what it doesn't do at the front is that it doesn't place an immediate burden on the state to prove the without consent. Is that the strategy of the prosecution in proving its case may take a number of fold. It may go back to coercive circumstances, it may go back to lack of consent, but what it doesn't do immediately is place that undue burden of without consent on the complainant, and that's really the complaint that we seek to remedy.
Okay, thank you. I just have a different take on it, and I think if the state must discharge its obligation to prove guilt beyond a reasonable doubt, then it must prove unlawfulness, whatever that might mean.
Yes.
If we take out consent, we don't know what that might mean.
Yes.
Or it must prove coercive circumstances. The state has the duty to prove that, and I think my sister Justice.
Yes, I agree that the state would prove intention.
So that burden still rests, and it would be the complainant who would be the first witness in the box.
It may be that, Justice, but as I said again, words matter. Without consent does place that burden currently. Perhaps the removal will not immediately place that burden. But I've also confessed that this is not a silver bullet in order to fix everything. But it would go a long way to ensure that there isn't that heightened secondary victimization.
Max Mukharani, did I understand the submissions that you make to be correct when you support retaining the subjective test for consent?
The
subject for consent.
Yes. So what would happen is that mistaken belief in consent is a criminal law defense that negates intention. So that would still remain, and it would be the burden of the accused in those circumstances to prove it. But what would not happen in our submission is that the complainant wouldn't have to prove the lack of consent.
If the subjective test for consent remains, how would this assist in cases like Amos and Coco?
I think in Amos, which unfortunately would not be continuing, but in Amos, what the submission that I've made is we would look at the circumstances in which it took place. And in those circumstances, the first point is if there was any false, fraudulent means in order to get a complainant there, that would already negate a mistaken belief in anything, because it would mean that this person had created a circumstance in order to coerce someone to have sex with them.
That goes to intent, doesn't it?
Yes.
And that We don't need to change the law
Yes,
to get there.
yes, Justice. So the submission that CALS is making, which is different from the Embrace project, is we're saying we understand that rape is an intentional crime, and we want to keep it unlawful and intentional, but what we seek to do is remove without consent, because the removal of without consent would not place a burden on the victim. But that doesn't mean that the accused, in asserting his defense, can't use consent as an affirmative defense, because that defense is available in criminal law anyway for any other crime.
The accused could still raise subjective belief of consent. So what would we be achieving?
So we would be achieving the undue burden that we are placing on the complainant, because Justice Theron, what we must understand is that the accused can, at the end of the state's case in terms of 174 of the Criminal Act, say the state has not proved its case beyond reasonable doubt, and therefore I am not going to enter the stand. What we are trying to achieve here as CALS is, in CALS's case, the burden is on the accused. We want the burden is on the complainant. We would like the complainant not to be placed with an undue burden. If the accused, sorry, Justice. My junior has given me something that I hope may answer your question. So even if the court were to keep the subjective test, in CALS's submission, our model would drastically reduce and narrow its reach. Once coercive circumstances have been proven, the claim for mistaken belief in consent becomes untenable, because we've already done away with its tentacles. You wouldn't be able to prove that you didn't create false pretenses, and therefore you mistakenly believed that someone is consenting. The accused state of mind cannot override the objective reality of things like force, intimidation, false pretenses, incapacity. That shift alone, Justice Theron, protects victims from indignity of credible contests. Sorry, Justice Theron.
Yes. I had understood CALS to be moving away from coercive.
Yes.
And my questions were based on that assumption. Now, in your answer, you're referring to coercive circumstances. So my questions was based on the assertion that CALS is no longer seeking words
Coercive circumstances to be read in.
Yes.
Yes.
Are you able to answer my question based on your submission that you're looking for a severance, and the severance just to take out consent?
Yes, thank you, Justice Theron. Again, if we take out without consent from the definition, we've got unlawfulness, and what unlawfulness does is that it creates a prima facie presumption that something is unlawful, and then the ground of justification goes to that unlawfulness. And
my question was, in that context, an accused would still be able to successfully raise a defense that he subjectively or she subjectively believed that consent had been granted.
Justice Theron, in that circumstances, I would say that the state has already got a heightened burden to prove their version beyond reasonable doubt. In the circumstances, what the state can do is that they can refute the accused's version of genuine mistaken belief in the element of intention, to say that in the circumstances, the accused would not have been able to believe that there was a mistaken belief in consent.
Yes, but we're going around in circles. And we seem to be ending up exactly where we are right now. And that's why I don't understand what effective change or what effective remedy or how effective that will be. But I think we should leave it there for now.
Justice Theron, just to perhaps say one thing. What the court would do by granting CALS its relief It would clarify the law, and it would make it clear what the unlawfulness is in rape. This would in turn impact how courts engage with the facts before, in finding whether there was or there wasn't consent, that the removal of consent, along with the clarification of Troko, would really go a long way. Because Troko had already spoken about, in assessing this mistaken belief, it must be reasonable. So removing consent, along with what the SCA has said, would really go a long way.
How would you respond to the questions that I put to Mr. Rajab Badlanda regarding interpreting the law to require meaningful consent?
Judge, I think meaningful consent would create the same problems of reasonableness. We know from the jurisdiction of this court in Blue Moonlight, for instance, and in Olivia Road, what the court has done was spoken about meaningful engagement. And one of the elements of meaningful engagement is reasonableness. And we say that meaningful consent would bring us back to the realm of a potential negligence or reasonableness step, which in our submission is really a role for the legislature to consider.
Thank you, Ms. Moghrani.
Thank you, Judge.
Justice.
Thank you. Ms. Moghrani, I just have one issue to deal with you. At paragraph 130 of your submissions, you make reference to the Lesotho case of Rex versus Makebe.
Yes.
It seems to me you read in much more than I do in that case, because the only sentence dealing with consent in that case reads as follows: I'm not persuaded that at the end of the day, the defense was able, through cross-examination, to show that the sex was consensual. So it says, one, that consent is still a defense and an element that the state must prove. It does not say that the accused must prove, as you say, on a balance of probabilities. It does not mention those words, as a matter of fact.
I can accept that submission, Judge. But what I want to say, Judge, is that Lesotho, in its definitions, does move towards coercive circumstances. And so the effect of move towards coercive circumstances is that consent becomes an affirmative defense rather than a burden that the victim must prove. I just wanted to say thank you with gratitude to the court for referring to me with the correct prefix, MX. I really appreciate that. Thank you.
Ms. Iran for the Mickey, first and second Mickey. Oh, you, Ms. Kruger? Yes.
Thank you, Justice Mhlantla. Yes, I appear together with my co-counsel, Ms. Thambiran. Before I begin, though, I just want to ask whether the court might wish to adjourn for lunch. I'm very happy to continue, but I am conscious of time.
We want to hear you.
I'm indebted, Justice Mhlantla. Good afternoon, Justices. My name, as I said, is Ruth Kruger, and I appear on behalf of the Centre for Human Rights, and as well as the Psychological Society for South Africa. My co-counsel, again, as I said, is Ms. Timika Thambiran, and the two of us will each be presenting a brief argument during our protected time. My role in this address is to briefly sketch the psychological background to sexual violence. And I will make 2 short points in this regard. My first point relates to so-called peritraumatic responses, which various of my colleagues have already referred to. And my second point relates to the broader psychosocial context of survivors of sexual violence. Firstly then, peritraumatic responses. These are responses that occur during or immediately after a traumatic event. In particular, there is a spectrum of responses known as the defense cascade, which are hardwired into our psychology. The first 3 responses in the defense cascade are fairly self-explanatory. First arousal, then fight or flight, and then the freeze response. The 4th response in the defense cascade is tonic immobility, or temporary paralysis. Tonic immobility may appear to be an extreme response, but it is not an uncommon one. A Swedish study on the phenomenon found that more than 70% of rape victims reported significant tonic immobility during the assault. The 5th response in the defense cascade is collapsed immobility, fainting. This may lead to a complete loss of consciousness or merely compromised consciousness. Responses to sexual violence take various forms, and I do want to emphasize that none is incorrect. However, it is worth noting that the peritraumatic responses of freezing, tonic immobility, and collapsed immobility are all passive responses. And more than that, they are likely to prevent a survivor from being able to communicate their lack of consent. This concludes my first point. I would now like to discuss the importance of psychosocial context in determining how a survivor understands and also communicates consent. An important and relevant element of psychosocial context is gender-based violence. I do apologize. I meant to say gender-based discrimination. I think we've been talking about gender-based violence a lot today, of course. But what I seek to point to is gender-based discrimination, and the impact of that phenomenon is that a woman's individual capacity to give or to refuse consent may be inhibited by a relative social incapacity. We know, though, of course, that gender is but one aspect of an individual's identity. Discrimination operates along multiple axes, such as gender, such as race, such as class. It is intersectional. In the context of sexual violence, intersectional discrimination will only add to and complicate a survivor's social incapacity, and it will limit her ability to give or to withhold consent. We can take this point on intersectionality further, though. Intersectionality is a lens which may assist in understanding various social phenomena that impact upon the understanding of consent and the expression of consent. One example of such a phenomenon is sexual scripting. Depending on whether one is a man or a woman, homosexual or heterosexual, rich or poor, one receives a different sexual script with a different allocation of power. Women are commonly scripted as passive recipients of sex, and this leads to the normalization of sexual violence. It may limit a woman's perception of her right to withhold consent. In summary, quite simply, the Amicus submit that the psychology of consent affects how it is understood and how it is communicated. Peritraumatic responses must be considered, as must intersexual discrimination. Ultimately, the concept of consent is decidedly slippery. This concludes my second point. My co-counsel will now take over to demonstrate how these psychological realities speak to the various submissions that have been made in this matter. Thank you.
Ms. Crook.
Justices, I rise after my colleague to carry the first and second Amicus psychological and academic insights into the very heart of the relief that is sought, and I'm going to jump straight into it, mindful of the time. The first and second applicants are asking this court to align our criminal law with the lived reality of sexual violence. They are seeking a narrow but a very critical remedy, that an accused's mistaken belief and consent must be objectively reasonable. The High Court identified the defect very clearly. The impugned provisions currently tolerate a defense of mistaken belief even when no reasonable steps were taken to verify that consent was in fact present. It then read in a requirement of reasonableness as a constitutional correction. The amici submit that this correction was not just justified, it was vital. The amici submissions have very clearly demonstrated that many survivors of sexual violence do not shout, struggle, or flee. Instead, in the crucible of sexual violence, the body may freeze, the mind may fold inward, and language may very well vanish. And these are not signs of acquiescence. Instead, they are the neurobiological marks of automatic, passive peritraumatic responses, which may silence voices and still the limbs. Layered on these automatic reactions are the intersecting vulnerabilities, such as intimate partner coercion, rape myths, and sexual scripts. These can prevent survivors from recognizing that what they're experiencing is even abuse, let alone allowing them to articulate their non-consent. It is our submission that the defense of mistaken belief in its current formulation transforms this silence into a shield for the accused. It effectively reintroduces by stealth the long-abandoned resistance requirement that our law once buried. The defense of mistaken belief has effectively evolved into a substitution for the resistance requirement, and this was very clearly demonstrated in Ms. Holtztrager's case. According to her testimony, she experienced many passive peritraumatic responses. She said she felt as though she was in a trance-like state, and so she could not articulate her non-consent to the acts in question. But because she did not signify her opposition to the acts in any way in an outward manner, the court found it impossible to find that the accused subjectively knew that he did not have consent. And so we submit that to continue with the current formulation of the defense of mistaken belief and not have it be subjected to reasonability will have the effect of ignoring the very well-established psychological findings on the barriers to the expression of non-consent. This is because the defense of mistaken belief acts as an unreasonable barrier, particularly to survivors who experience passive peritraumatic responses or whose intersecting vulnerabilities bar them from communicating non-consent. And so in this way, confirming the High Court's order would thus ensure that the accused's belief must be reasonable, creating a trauma-informed, survivor-centered framework, a framework that does not mistake silence for agreement. Turning now to the relief sought by the Center for Applied Legal Studies. The CAL's relief is much broader, and some might consider more radical. It asks this court to strike at the root of the problem by removing consent as a definitional element. Here again, the amici's insights provide a crucial bridge. The amici's submissions on peritraumatic responses and the intersecting variables that shape how consent is communicated and understood demonstrate the immense complexity and nuance involved in understanding consent and communicating it in the context of sexual violence. Consent is not a simple concept. It's shaped and distorted by trauma, unequal power, fear, and dependency. So requiring survivors to prove their non-consent is to impose a burden that is often impossible to discharge. It's to require words when trauma has robbed language, or to require resistance when the body has been locked still by terror. The amici submissions therefore show that the demand for the proof of non-consent collides with psychological understandings and constitutional guarantees. The amici submissions demonstrate that consent is too difficult to pin down and should perhaps be removed from the definition of rape. In this way, the psychosocial reality of consent and the reality of passive peritraumatic responses is strongly aligned with the relief that CAL seeks. Justice is mindful of the time. I'm not able to comment at this point on the amici submissions in relation to the Women's Legal Centers Trust, but we would definitely be able to answer these questions should the justices request so. But turning to conclude, the amici have placed before this court more than just argument. Apologies, Justices. If I could just conclude my point.
You can conclude.
Thank you. Thank you, Justice Mhlanga. We bring a lens that transforms how the law understands sexual violence. Our submissions show that consent is a deeply layered concept. It's shaped by the brain's responses to trauma, but also social scripts that teach silence and structural inequalities. We want these insights to not just be peripheral, because the amici admit that they are essential to a just assessment of consent. They fortify the relief sought by the Embrace Project and Miss Holtztrager, but they also equally sustain the broader remedy urged by CALS. And so, Justices, we are asking that our criminal legal framework be developed in such a way so that it sees the full reality of sexual violence and responds with the constitutional fidelity that justice demands. May it please the Court.
Thank you, Ms. Tambiran. On relief, now that you are still there, I'd like to understand, you seem to be supporting both the relief sought by Embrace and also the one that is sought by CALS. And I'm not sure if I understand how that would work. Because CALS says you must serve anything that has to do with consent, and you know what Embrace is seeking. Is it possible to support both or what?
Justice Mshanta, thank you for the question. I appreciate that it does appear quite strange that when the applicants themselves are at such loggerheads with each other, that we would be supporting both sets of relief. And I think that the overarching submission that the amici bring into this conversation is that the current position is untenable because it doesn't factor in these well-established psychological insights. And so, yes, we do support the relief that is sought by the Embrace Project and by Ms. Inge Holtztrager. And the way that we can situate the amici submissions within what the Embrace Project is asking for is within the reasonable steps test. We would submit that the reasonable steps test requires the accused to have taken reasonable steps to ascertain whether there was consent. And so this supports a view that would then require an accused person to do more than just accept passivity as consent. We know that that is a fundamental notion in our law. Cases such as Rex versus Swigula, Mudridge versus S, and most recently in the case of Coco versus S as well, has recognized that passivity does not equate to consent. But what we are seeing unfolding is that when the defense of mistaken belief is not subjected to reasonability, that notion is ignored. And we are seeing a situation where the passive peritraumatic responses and the notion that that does not equate to acquiescence or consent is not taken into consideration. So we situate our submissions there within the reasonable steps test to say that it must be factored when we are asking whether an accused did enough to ascertain whether there was in fact consent instead of just accepting non-communication as non-consent. But broader than that, Justice Mhlantla, I think the amici submissions really demonstrate just how complex consent is as a notion. There are so many factors that influence it, whether it's the intersecting vulnerabilities of a survivor to recognize the situation they're in is abuse, and then it prevents them from articulating the non-consent, or whether they're experiencing an automatic peritraumatic response such as tonic immobility. It's impacted by rape myths, social scripts, etc. It is simply just too difficult to actually encapsulate that into a single definition or understanding of consent. And so our submission in that regard is that where consent is treated as a central determinant for the successful prosecution of rape, because we know that the legal definition currently requires a survivor to prove their non-consent. Where we recognize that consent is that central determinant and the successful prosecution rises or falls on that ability to prove non-consent, but to also recognize that consent is so complex, too difficult to pin down, and impacted by a number of variables, it is to allow a situation that recognizes that the inclusion of consent as a definitional element presents an unfair and an unreasonable barrier to survivors of sexual violence, but to leave the situation as it is. And so in this way, the amici submissions are very strongly aligned with the relief that the Center for Applied Legal Studies seeks.
Sorry, I have just one question. I mean, speaking for myself, this case has also been an education for me in terms of understanding this notion of the peritraumatic responses and how that feeds into the defense cascade. And it seems to me that one could have a variety, but quite a diverse variety of responses.
Yes.
And clearly one needs to take those into account. But in the context of importing that, for example, into how courts work and into how individuals start thinking, when we have a big challenge. Because in a sense, if one uses that as the basis to assess reasonableness, it might be so unfair, at least in the early stages, where people might say, well, I saw that response, not as a negative response, but as a positive response because the response was located in not fighting or in arousal or something like it. So how do you see that playing itself out beyond, as it were, the psychological and social basis of what you're contending, but really transporting them into courtroom and in dealing with them in a practical way, which is where you say it must end up, not so?
Yes. Yes, Justice Culpin, and we do accept, I think, let me start first by saying that we do accept that our submissions are quite complex and very academic in nature, and to expect the ordinary layman on the street to know about these responses and that it doesn't necessarily equate to consent it is quite difficult to accept that. And my learned friends have spoken to the fact that someone who lives in a more remote area who is not exposed to a lot their understanding then of peritraumatic responses would then be impacted. I think, though, however, that our courts and our jurisprudence has long recognized that passivity does not equate to consent, and that a lack of resistance does not mean that you are willingly submitting to an act. And that's where the peritraumatic responses finds its relevance. So whether it's judicial application, that our judicial officers, our judges, and our magistrates need to be alive to this fact, to accept that a lack of resistance is not necessarily a non-consenting indicator. I think that would go a very far way in assisting our courts to be more survivor-centric when they're adjudicating on cases of rape. I think particularly in the context of Miss Holtztrager's case, like we said, she had testified to the fact that she felt as though she was shell-shocked. That was one of the ways that she described feeling, but also she described feeling like as though she was in a trance. And that very clearly speaks to passive peritraumatic responses like tonic immobility. And that prevented her from signifying her opposition to the act in any way. There was an understanding and an appreciation by the learned magistrate that that did not mean that she was consenting. But because the subjective test was applied, it had the law peering through the eyes of the accused to subjectively understand whether or not there was consent. That's where the difficulty came up. And so we submit that the courts would be able to accept these principles and to be able to apply them in a way that their approach to the prosecution of sexual violence is much more trauma-informed and survivor-centric.
Thank you. I'm not suggesting that they're academic and they're irrelevant. They're very relevant.
Yes.
And clearly the courts have a role to play, but maybe organizations that you represent may have a bigger role to play as well in educating society about how these things work.
Absolutely, Justice Collipin. I think capacity building in that way is definitely something that that can be approached, and organizations like the Center for Human Rights or the Psychological Society can play a role, but it's also in our intervention, in cases like this, that also solidify these perspectives, and it allows for this court to cite them with approval, and to provide a mechanism either for the interpretation of the current framework or even the interpretation of an amended framework as well. May it please the court.
Questions from the court, but you may have something that you wish to state or say before we ask the questions. So we'll give you 15 minutes to do so after lunch, not now. I'm just trying to prep you so that you know that you have 15 minutes and not the 30 minutes until that time.
As the court pleases, Justice.
Thank you. We'll adjourn until Kurat. Ms. Poswal-Leochodi? On the mic?
Okay. I would just like to confirm what I am supposed to do. The instructions you gave just before lunch. I just wanted to confirm that mine is simply to answer questions. Yes.
If you had anything that you wanted to say before we pose questions,
All right.
you may do so.
Yes, thank you, thank you. I think perhaps I just need to clarify that we are here having filed a notice to abide. We are here really to comply with the constitutional imperative in terms of Section 165, subsection 4, that requires that state parties be available to the court irrespective of whether they are challenging the matter. So that is why we are here today. Secondly, I just wanted to clarify as well the issue that was raised about the fact that we are raising new issues. We are not raising new issues. The issue was raised by the High Court, and it appears in paragraph 50 of the judgment. So in that paragraph, the court specifically makes reference to our submissions regarding the issue raised by the first and second applicant. Also, I would just like to say that the law on rape has developed, it has advanced, and jurisprudentially and legislatively, there has been a lot of progress made regarding the law of rape. Rape has moved from the principles, in fact, that were applied in rape have changed, and great strides have been made with regard to the law of rape, from the requirement that there must be a hue and cry when, in order to prove that the survivor was indeed raped. That has been done away with, and legislation has, as well as the courts, have found that that is bad law, and therefore it's no longer applicable. The fact that spouse can espouse, there can be a rape between spouses, the fact that there must be a first report, all those principles, which were traditionally applied in rape cases, have all really been removed, and Judge Nkabinde has acknowledged that in the case of Masia. Judge Langa as well has acknowledged that. So just to give the court a synopsis that we are no longer where we used to be. Great strides have been made, and Justice Ngabinde credited the women's rights groups. We contend that the state also had something to do with the progress with which we are at, as well as the Constitutional Court. So, just very briefly, we are not where we used to be, and we cannot pretend that there isn't a change in the manner in which rape cases are applied. I think that would be all. Yes. Those are my submissions.
Just two aspects from my side. The one relates to how the minister dealt with the matter or responded to the call by the court to file answering papers. We initially issued directions in November calling on the parties to file answering papers and submissions. Nothing came from the minister. We eventually had issued further directions reminding the minister to file. We seem to be getting that problem lately, especially in confirmation matters where we don't get any response from the minister who is supposed to be, not only this one, of course, but minister are supposed to be the custodian of legislation. And when there is a challenge, we expect them to respond and assist the court. But lately we have to actually go back, issue directions, numerous occasions. Why is that?
My lady, I think the problem with getting instructions, especially for counsel, I think is well known. And in this instance, though the directive was issued in November, if you can see in our condonation application, we were not aware of that. Our attorney had not received the directive. And in the interim, there was a change of cabinet ministers. The minister had insisted that she needed to apprise herself of and acquaint herself with the matter fully. And because it is a matter of public importance, I'm not too sure, she needed to have a better understanding of the issues as a new minister. And I think that is what occurred. And also I need to say, we filed the answering affidavit that should have just been an explanatory affidavit, but it's a case of too many cooks spoil the broth. We are liaising with many people, and in the end, this is what happened. And I think even for the minister, that was what the problem was.
We are told that the minister abides the decision of the court. But in the affidavit, you see that there's a facilitation. In some instances, what is there appears to be in opposition to the confirmation proceedings. What is the current state? What is the position of the minister?
Justice Mhlantla, what we will have to do is to abandon whatever aspects that have been raised which could be deemed to be oppositional to the application of the applicants, because our instruction was to abide by the decision of the court. And if certain matters have crept in, that would mean that we're going beyond our instructions. Our instructions remain, they haven't changed. We are to abide.
With the applicant, I noticed that the minister seeks a period of 36 months to remedy the defects.
Yes.
There is a concern that was raised. I don't know whether you have any comments to make. the period.
Yes, as far as that is concerned, Justice, we discussed with my elderly friend and she was agreeable to the 36 months because at the end of the day, what does occur is that matters keep coming back because the time limits are not met. So as far as that is concerned, I discussed the matter with the first counsel for first and second applicant and I beg your pardon. It seems she doesn't agree. But as I say, the 36 months is practical because it gives the legislature the time to work on the legislation. And rather than applications being brought before this court for an extension of time, that saves those circumstances, my lady. Justice. Yes.
I must say, I just want to indicate that the way the ministers litigated in this case leaves much to be desired. Now, this explanatory affidavit doesn't explain as much as it opposes this relief, it seems to me. Because you make expansive submissions on why the impugn provision passes constitutional muster. How must we interpret those submissions of opposition?
As I said to Justice Mhlandla, we would withdraw any matter or any arguments or submissions that have been made that would be oppositional to abiding.
I must also say, in this court, we tend to deal with the issues and the merits and not dwell on preliminary issues like condonation, but the periods of delay in this case is really very worrying. I understand there was a different minister, but how long does it take for a new minister to get au fait with what this case is all about?
Justice Majid, I really can't take the matter any further, save to just repeat what I said to Justice Mhlandla. We would not have been privy to that. We were constantly, as counsel and the state attorney, reminding the minister of the need to respond. There is nothing else really we can say.
Now, what does this mean? I'm reading from your written submissions. You preface this remark with the observation that the first and second applicants do not oppose the application for condonation. Now, you say the first and second applicants have opportunistically argued that this honorable court should grant a cost owed against the respondent due to the manner in which they conducted. And then they say, you say later on, this is just an opportunistic method of marketing the minister in costs. What does all that mean?
Yeah, it means that the first and second applicant, looking at the other parties, realized that BioWatch will apply, and they are now thankful to having the minister to make the claims and stake a claim for costs. That's what it means, Justice Majid.
You then say in paragraph 15 that because the respondents, that's you, have explicitly stated that you abide the decision of the court, you should not be ordered to pay costs. Are you familiar with the decisions of this court which say that the minister in cases like these should bear the costs when there's a bona fide, a genuine attempt to launch a constitutional challenge? Unless you're saying this is a frivolous challenge by the applicant.
No, I'm not saying this is a frivolous challenge, Justice Majid.
See, this is strong language, and it worries me that the minister, A, being late, and B, mixing up explanation and opposition, and would make a submission like this, where parties, very, very important matter about a societal issue which is cause severe ructions in our communities would say something like this about parties who come to court genuinely to challenge this, this provision. Provisions. Let me just say this, I don't think it's proper. We act for the minister, whose constitutional duty it is to come and explain to the court the reason why the statute reads the way it should, to come with submissions like these, because this is a serious matter, and these parties, I mean, the one applicant who's here, she was a victim of the crime. How could one possibly say it's an opportunistic move to mark the minister in costs?
Justice Majid, there was no ill intent in the response to the first and second applicants. And
You know, some of the counsel said earlier, words matter, and they do.
And I apologize if the words are construed as being strong.
Ms. Postbol-Leratori, how would the relief sought by the applicants amount to a reverse onus if the state is not relieved of proving an element of a crime? Because I understood that to be what the minister was saying.
My lady, we have abandoned that course. Justice Theron, we have abandoned that course.
Have you also abandoned the argument that the proposed relief will infringe on an accused's right to remain silent?
That is so.
Thank you very much, Ms. Postbol-Leratori. Thank you, Justice.
Thank you, Ms. Postbol-Leratori. I really don't have a question, but I just want to put something to you which I think must complete the proper context. You reminded us of the enormous strides we've made as a country in dealing with gender-based violence, and you're saying that we're in a much better place now than we were ever before. And I think I would agree with you, but I'm not sure if that's the question that we should be sort of celebrating, because I think the question is, are we in a place now where we could and should have been, given our commitment to ending gender-based violence and sexual violence against women and children? I mean, our president not so long ago spoke of sexual violence as being a betrayal of our constitution and an affront to our common humanity. So surely it's that must occupy this court today, while we can take cognizance of all the good things that we've done. But the problem is that today in South Africa, 30 years into democracy, we're sitting with a problem that threatens on a daily basis the self-determination of women and children. And that's what must motivate us.
Indeed, that is so, Justice Kolopan. We cannot ignore the blight that sexual violence, gender-based violence, that persists in our country. However, we felt that in the discussions, there seemed to be no recognition of the fact that we have come this far. Indeed, we are a traumatized nation. We are a violent nation. Hence, the prevalence of gender-based violence. Indeed, I agree with you. That is what should actually, yes, occupy the mind of this court.
Thank you very much. Ms. Postbol-Leratori, was any consideration given to appealing this matter on the part of the state, the acquittal on the rape conviction? Because when one reads the decision of the magistrate, in my mind, it beggars some belief that there was an acquittal in this matter.
Indeed, Justice Savage, I am not aware, I don't have instructions in that regard, whether or not there was consideration, but I agree with you that there was certainly a cause and a reason to appeal the matter. Yes, Justice.
Thank you, Ms. Oswald-Rototi. Thank you. Thank you. Ms. Christian?
Good afternoon, Justices of the Court. All the applicants have emphasized the history of sexual violence as being rooted in patriarchy and the exercise of control and power by men over women and children. The Women's Legal Center readily agrees that violence against women is rooted in the historical patriarchy and power. However, we submit that it is disingenuous to recognize that historical power and control, and then essentially to infantilize men by accepting the contention that they labor under a genuine but unreasonable belief in consent when they enforce their patriarchal power over women. The Women's Legal Center's case is fundamentally that men know what they do. And it is a fiction, I submit, to create a lower standard of mens rea based on an artificial acceptance that the claim of belief was genuine but unreasonably held. To do so serves only to infantilize the very men which we say use their historic patriarchy and power to exert control and force over women. During my address, I hope to persuade this court that it is neither necessary nor appropriate to reduce the standard of mens rea to give credence to men's claims that they know not what they do. Instead, what this court can do is recognize that when evaluating claims of a belief in consent, trial courts must evaluate whether reasonable grounds exist to support that claim. I will also show that it matters not whether one calls it reasonable grounds or reasonable steps or objective factors, although the phrase reasonable steps appears to be inherently problematic from an evidentiary perspective. The point is that if there are no reasonable grounds to support the claim of a belief in consent, then the defense must be rejected as not being reasonably possibly true. And that is what happened in the case of Miss Holtztrager. That then is the roadmap of where I intend to go with my submissions, to which I now turn. There is no doubt that the prevalence of sexual violence and other forms of violence against women is deplorably high in this country. There can also be no question that the state, which includes the judiciary, has a legal obligation to address the scourge of this violence. What is doubtful is whether men perpetrate sexual violence whilst under a genuine but unreasonably held belief that consent had been given. There is certainly no empirical evidence to support the contention that that happens at a factual level. The real mischief identified in the confirmation proceedings is that men escape convictions based on their claims, or rather in many instances it appears to be arguments by the legal representatives or inferences drawn by the court that the accused believed that consent had been given. In the case examples relied upon in this court, the evidence identified in the judgments and the evaluation of the complainants and the accused evidence did not justify lowering the mens rea standard. In Ms. Holtztrager's case, the magistrate seems to have evaluated the state's case as though it was a Section 174 inquiry. I say that because the magistrate rejected unequivocally the accused's evidence as false and far-fetched, and then she appeared to reach her conclusion based on the complainant's evidence. the judgment of the magistrate is not paragraphed, but the section I intend to quote now is at volume 2, page 216, where the magistrate says, "The fact that the complainant did not signify her opposition to the acts in any way makes it impossible for the court to be satisfied that the accused subjectively knew that he did not have consent to proceed with the acts." The conclusion is difficult to understand in circumstances where the accused testified, and based on his evidence, the court should have evaluated whether it was reasonably possibly true that he held a genuine belief that consent had been given. Alternatively, and still based on his evidence, the court should have evaluated whether he foresaw the possibility that she had not consented. That the court did not do. Counsel for the embrace applicants argued that it was not possible to establish objective factors disproving the accused's subjective belief because, on Miss Holtztrager's version, she froze. But that's not the end of the inquiry. Mr. Amos gave evidence. And in any event, the fact that she froze is an objective factor. And since the Act defines consent as voluntary agreement, an inactive complainant is an objective fact pointing to the absence of voluntary agreement. And an accused then has an evidentiary burden to show that the complainant was an active and voluntary participant. And that is precisely what Mr. Amos stated in his evidence. He said that she participated in the sexual intercourse for which he was accused of rape. So Mr. Amos didn't come to court saying, "I didn't know," or I took her freezing as an implicit indication that she did not consent. What he came to court and said was, she actively participated. So he knew that the test for consent was whether she actively participated. That version was rejected by the court. Another objective fact on which the magistrate appeared to attach no weight in determining whether Mr. Amos had a genuine belief that Ms. Holtztrager had consented to sexual intercourse is the fact that he had invited her to a house party, invited her to her house under the pretext of a party, and the court's already identified that as a problematic evidentiary element of his evidence and the acquittal. And importantly, we also don't know what other objective facts there might have been, because this court does not have the full record of the evidence that was presented in that case. The point is that what is conspicuously absent from the magistrate's judgment is an evaluation of the defense of mistaken belief in consent against all of the proven facts. And when one considers the magistrate's comments on how the accused's version changed or was elaborated upon as he went along, there certainly does not appear to be any reason for her to have accepted as being reasonably possibly true any claim that he believed that consent had been given. I've stated in my written submissions that confirming the declarations of constitutional invalidity in effect tells Ms. Holtztrager that the regional magistrate was justified in acquitting the man who raped her. That is the wrong message. As happened in Koko, Ms. Holtztrager's vindication would have been had the state appealed that unsound judgment of the magistrate. And a similar criticism, but perhaps not as strongly, can be made in respect of the case of Mashego, relied on by the embrace applicants. There, the High Court set aside a conviction based on its finding that the magistrate had not considered whether the accused knew the complainant was mistaken as to his identity. The court acknowledged that there was a deviation between the accused's evidence that he had asked the complainant for sex earlier that evening and that she had said she was tired, and her denial that that conversation ever occurred. There is no explanation by the court, who sat as an appeal court, as to why it accepted the accused's version on that score over the complainant's. Again, the point is that the court did accept his version in finding that those facts did not point to a scenario of the accused knowing or foreseeing the possibility that the complainant was consenting to intercourse. We cannot evaluate the soundness of that judgment because we don't have the full record in order to evaluate whether the appeal court was justified in accepting the accused's version. The embrace applicants do not explain how these judgments would have been decided differently if, based on the evidence as evaluated by those courts, the mens rea threshold had been lowered to require a reasonable belief that consent had been given. It seems that if the courts apply the principle that a claim of belief in consent must be evaluated against proven facts, then it is difficult to imagine that an unreasonably held belief could ever be reasonably possibly true. And that applies both to the evaluation of an actual belief in consent, dolus directus, or whether the accused foresaw that consent might have been absent, dolus eventualis. If the proven facts show that a complainant was not an active and willing participant in the sexual conduct for which the accused is charged, the only inference that can be drawn in those circumstances is that he must have and therefore did foresee that consent was not given. If the existence of intention is evaluated in this way, there is no reason to infantilize men by assuming, for the purposes of criminal liability, that they genuinely believed consent was given, and then to lower the standard to ask whether such belief, which isn't as a factual level accepted by a court necessarily, but whether that assumed belief was reasonable. I've gotten about halfway through my address, but I'll leave it there. The court like me to continue?
Ms. Christian,
Yes,
so I
Justice
understand your submission to be that the error lies in the interpretation of the law and not in the language of the law.
That is my submission, Justice Tron.
And that the declaration of invalidity should not be confirmed.
Correct, Justice Tron. May I elaborate on why that is so?
Yes, you may.
What the embrace applicants are asking this court to do is twofold. In the first instance, it's asking this court to declare the sections which require intention as an element of the crime of rape to be unconstitutional. Flowing from that, they propose an interim remedy which requires an accused to show that they had taken reasonable steps in order to establish that consent had been given. The link between the two, as I understand it, is that in showing the reasonable steps, the accused would then illustrate that his belief was reasonable. And if the accused is unable to show that reasonable steps had been taken, then the conclusion can be reached that his belief was unreasonable. And the Women's Legal Center's case is that while we can float around the idea of an unreasonable belief in consent, it seems, particularly in the case of an intimate crime such as rape, that an unreasonably held belief could ever be said to be genuinely held. And it's useful to highlight that one of the jurisdictions from which the embrace applicants have drawn the requirement for reasonable steps is the Canadian jurisprudence. And I've highlighted in my written submissions academic criticism of the introduction of the reasonable steps. The embrace applicants in their responses to the Women's Legal Center submissions have referred usefully to a Supreme Court judgment in Canada, and that judgment is R versus Barton, referred to in the embrace applicants' submissions in response to the Women's Legal Center submissions. And the court there actually does deal quite usefully with the purpose and import of the reasonable steps requirement. And if one has regard to the Canadian legislation, together with how the court had explained its purpose and import, it's clear that the reasonable steps requirement, even in Canada, does not serve to illustrate that an accused's claim of belief in consent was reasonable or that his claim of consent was unreasonable. What the Canadian statute does is it says, if you haven't taken reasonable steps, it is not even available to you to raise the defense of mistaken belief in consent. And their judicial system is different to ours because they have a jury system. So the Section 2732B, inquiry into reasonable steps in the mistaken belief in consent, is introduced at the level of a judge deciding whether or not the jury must consider whether the mistaken belief in consent should be considered by the triers of fact, being the jury. So before that issue is even referred to a jury, the judge sits and says, I've heard the evidence. Based on what I've heard, there either are reasonable, there's evidence of potential reasonable steps, and if there is, he refers it to the jury to decide the facts. If he's not satisfied that there's any evidence pointing to reasonable steps, then the instruction to the jury is, you don't even consider whether he had a mistaken belief in consent, because that defense is no longer open to him. What happens once the jury does get the inquiry as to mistaken belief in consent, after the judge has determined that there's evidence pointing to reasonable steps? The jury then considers whether the existence of the belief is reasonably possibly true, based on whether or not there are reasonable grounds to support that factual finding. And I'll highlight the relevant paragraphs of that judgment because it sets it out very usefully. And it's at paragraphs 110 to 113 of that judgment. And the court deals with the reasonable steps requirement from paragraphs 101 to 109 as well. So the most useful elements or parts of that judgment is from paragraphs 109 all the way to 1013, because it explains the context in which reasonable steps have been introduced into the Canadian law. And it's not, the aim is not to establish a reasonable or unreasonable belief in consent. The aim is to test whether the claim of consent is true or reasonably possibly true. And so the intention...
So your submission is that the embrace applicant's use of that test is misplaced in our context?
It doesn't fit into the South African context in the way that the embrace applicants have set it out in their notice of motion, and the way in which the court, in the High Court, confirmed or granted the declaration of unconstitutionality and the interim relief.
And was this raised in the High Court?
For my part, I was not in the High Court. Obviously the difficulty is that the High Court's judgment doesn't point to any cogent opposing arguments to the constitutional challenge before it. We're told that the evidence or the arguments relating to the applicability of Dolus eventualis was ventilated in the High Court, but the High Court's judgment is silent on those arguments. So whether or not those submissions were made, the argument is certainly, or my submission is certainly that the High Court appears not to have taken into account those submissions dealing with Dolus eventualis. The manner in which the reasonable steps and the reasonable grounds requirements in the Canadian law have been adopted in that country, I submit, fits in logically with the manner in which our courts consider intention, whether it's Dolus directus or whether it is Dolus eventualis, because what it requires, as our law requires, is for courts to look at the objective factors and then to determine whether there is an air of reality to the claim that the accused believed that consent had been given.
How different is the manner in which the reasonable steps test has been adopted in the United Kingdom compared with that of Canada?
If I can just get there, so what the United Kingdom, of the jurisdictions that the applicants have, that the embrace applicants have referred to, is the only thing that is linked, has drawn an actual finding that the belief must be reasonable, and then coupled with that, the evaluation of whether the belief must be reasonable introduces a reasonable steps requirement. I just want to find the actual wording of that of the provisions. I have it from the Embrace applicant's written submissions. So the history of that legislative introduction is also important. What the Embrace applicants say at paragraphs 96 and following of their written submissions, the main written submissions, is that in the United Kingdom under the common law, as explained by the House of Lords in 1975 in Morgan, if the accused had a mistaken belief in consent, even if there was no reasonable basis for this belief, then the mental element of the offense was not satisfied and they are not guilty of rape. And I submit that there is where the previously prevailing situation in the UK is different from how our courts have adopted the test for intention. Because it's clear that in 1975, the court in Morgan said it doesn't matter what happened on the ground or what the objective facts were. Even if there's no reasonable basis for the belief, if the accused says he believed it, that's enough. And then the legislature appears to have codified that interpretation of the law. And so in 2003, justifiably, given that the law as it stood didn't require courts to look at whether there was a reasonable basis for the formation of the belief, the courts required that the belief be reasonable and that in testing the reasonableness, the court must ask whether a belief is reasonable is to be determined having regard to all the circumstances, including any steps A has taken to ascertain whether B consents. So the introduction of the reasonable steps is consistent with how our courts apply the test for intention, because our courts recognize that you look at the objective facts and you determine whether there is a basis for this claim of belief. The UK did not recognize it, and that's why they introduced the lower threshold of an unreasonable belief and then introduced the requirement to take reasonable steps in order to establish that the belief was reasonable. South Africa at this stage doesn't need to go that far, because even at the level of testing subjective intention, the courts are permitted and required to look at the objective factors.
Are you saying even in terms of the way the existing test is applied in South Africa, courts are required to look at objective factors?
Correct, my lady. And that is because the evaluation of intention is not just the mere say-so of the accused. Our courts have recognized that inferences may be drawn from the objective proven facts. And so when we look at the objectively proven facts, even though, as Justice Musi said, you can't get into the head of the accused, what the court can do is saying, I'm looking at all of these facts, and based on those facts, the only inference that I can draw is that either you knew that consent was absent or that you foresaw that consent was absent. Those are inferences that the court is entitled to draw in order to satisfy itself that the requirement of intention has been established.
Thank you, Ms. Christians. Thank you, Justice Mhlahla.
And you say if the relief sought by Embrace is granted, there's a risk of unintended consequences. Can you please elaborate on that?
Thank you, Justice Mhlahla, for that question. The risk of unintended consequences arises, A, because our courts have to date not been required to consider whether a lower threshold for mens rea is required. And what the Embrace applicants have proposed as an interim reading in is that in order to establish whether a belief is reasonable, an accused must establish that reasonable steps were taken. And the leap there is it requires a fundamental law reform, as this court has identified, in changing the mens rea element in rape cases. But what it also does is it opens uncertainty in how the courts are going to evaluate sort of a tiered approach, because one can imagine that prosecutors are going to come to court in the main to say that you intended, that your conduct was intentional. And if the court then based on reasoning such as that was applied in the Amos judgment, finds that that high threshold of intention has not been met, then the courts then have to go into new territory and establish whether, having accepted on an artificial level that there is a belief, whether the court must then now evaluate whether that belief is reasonable. And it introduces an unnecessary element and step in the prosecutorial process when that very test of reasonable steps properly construed can be introduced and evaluated with reference to whether intention has been established. So we're introducing a complex law reform in the judicial process for which there is no precedent in this country. And the court, if you have regard to the Barton judgment, will show that 30 years after the reasonable steps requirement was introduced in Canada, there was still uncertainty as to what its application actually required. So we're asking this court without any evaluation, or the embrace applicants are asking this court without any evaluation of the practical effects of this law reform, to introduce a second tier, a lower tier of mens rea, for which we don't know what the consequences will look like. The other unintended consequences, and the more nefarious unintended consequences, is that with reference to other legislation, it's been shown that if there is an area for violent men to exploit in order to undermine and silence their victims, they do so. And I'm sure this court can take judicial notice, as all of your experience in the lower courts will illustrate. The best example is in the domestic violence and harassment matters. As soon as a complaint is lodged for domestic violence or harassment, there is a counter-complaint. And the counter-complaint, more often than not, is frivolous, but it is aimed at silencing the victim. And if one introduces a requirement, an undefined requirement of requiring an accused to take reasonable steps, there is a real risk that an accused in those circumstances will come back and say, well, what steps did you take to establish that I've consented? And then you have the same tit for tat as you have under the domestic violence and harassment laws. And I accept that the embrace applicants point that is speculation, but unfortunately it's speculation based on what we know about violent men in this country. And the risk of this court confirming the declarations of unconstitutionality is that there's no going back from that. If this court gives clarity on how intention should be evaluated and emphasizes the need for lower courts to consider the objective facts in order to determine whether the belief in consent is reasonably possibly true, that will be sufficient to address the actual harms that are identified in these confirmation proceedings. Whether it is appropriate or necessary for the legislature to introduce an alternative mens rea requirement is something best left to the legislature, unencumbered by a direction of this court. And I say that particularly with reference to Justice Collipan's question to the counsel for the embrace applicants, is that, and Justice Collipan asked whether tampering with the legislation will help in the problem we seek to address. And if this court accepts that there is the risk of unintended consequences, if this court has declared the current provisions unconstitutional, and Parliament then has to fix it as it were, if those unintended consequences materialize, there's no going back, because this court has already said that the current system is unconstitutional. Whereas if this court gives guidance as to how intention should properly be evaluated and applied, Parliament will still be at liberty to introduce an alternative, a lower standard of mens rea. And if the unintended consequences then occur, parties will be able to challenge its constitutionality based on the results of that law reform. But if this court says that the current system is unconstitutional, that it hamstrings both Parliament and future litigants in challenging a law for which we don't actually understand the full consequences that might arise.
Justice Collipan.
Ms. Albertine, I'm just trying to understand, are you saying that the idea that a subjectively held belief is one that could never be unreasonable. Because if it's unreasonable, then it can't be subjectively held. And so,
Essentially, that is what I'm saying, Justice Collipin. But when the court evaluates it, it doesn't have to go that far. It can simply say that it's not reasonably possibly true.
so on that basis, you then would say that the High Court was wrong
Absolutely.
in how it analyzed what it characterized as the problem, and that the SCA in paragraph 32 in COCO was also wrong. Well, it didn't use that language, but it's clear, but it's reasonable to interpret that as suggesting that if the accused may escape liability on the basis of absence of knowledge of unlawfulness, if you believe the complainant was in fact consenting, it suggests a subjective belief. Now, if that's the case, then there's no need for dolus eventualis in that scenario, isn't it? Because then,
Dolus eventualis
if
still does.
your belief is, your belief is either in or out, finished. If it's reasonable, then it's subjectively held, and then you're entitled to your acquittal, correct?
Correct.
If it's unreasonable, then it's not subjectively held, then you can't rely on the defense of consent. Then you get convicted.
Correct.
So there's no scope for dolus eventualis in your analysis.
There is scope for it, and in the main, I would say judgment in Amos was wrong, because based on the factors that are highlighted in the judgment, there is enough of an indication that if we had the full record, dolus directors might have been satisfied, because the court could then say, because I'm rejecting your evidence, I'm not accepting the contention that you believed that consent had been given as reasonably possibly true. But even that analysis does find a place in dolus eventualis, because it...
Surely if the court rejects that, then the court must convict.
Correct.
The court doesn't have to rely on dolus eventualis.
It doesn't have to. So the inquiry will always first be dolus directus. And if dolus directus cannot be established, then a court will look at, well, even though I cannot exclude the possibility that you held this belief, still applying the objective or the reasonable grounds to establish the belief, there's still scope to interrogate whether you must have foreseen that consent was absent. And that, it might arise more pertinently in cases where there's, as Miss Holtztrager pointed out in her evidence, that she froze. So a court might end up finding that based on the evidence, because for whatever reason, it's difficult to think of it in a vacuum, but because of the evidence that was led, I cannot entirely exclude the possibility that you held the belief, unreasonably or reasonably. But based on the factors, you must have foreseen that.
Sure, but now you're saying that it's possible for the court to conclude that you could hold a belief unreasonably. That's what you're saying now.
I hear what you're saying. And the difficulty is we're dealing with thought experiments. And
yeah, because earlier you said that's not possible. That if your belief is unreasonable, it can't be subjectively held.
I don't want to go...
Whether, in a sense, the problem that was identified is in fact a problem, and it may well be. Because if you give the example now that it's possible a court could conclude that you hold this belief, but you hold it unreasonably, then you say the court must have resort to dolus eventualis. But dolus eventualis might not assist in that case because it requires subjective foresight. And then there's a gap.
Again, if I could answer the last part first, is the subjective foresight still requires a court to consider the objective facts in order to determine whether, based on inferential reasoning, the court can find that the accused must have foreseen that consent was absent, and therefore impute that foresight to the accused and say that you're guilty, dolus eventualis. And because courts always mention but don't deal with it pertinently, this notion of an unreasonably held belief. In the main, my submission is that an unreasonably held belief is rarely, if ever, going to meet the threshold of being reasonably possibly true. But I don't want to be seen to exclude the possibility that upon evaluating the evidence, it might still be necessary to conduct a Dolus eventualis test. The point is that, based on either approach, the court in Amos got it wrong. And so there is no factual basis to say that the law requires the mens rea standard to be lowered in order to fix those cases where courts get it wrong.
Sure. That is all. Thank you very much.
I'm indebted to the court.
Thank you. Reply.
Thank you, Justices. Justices, there are various things that have come up during the arguments of my learned friends. I'm going to try and keep this very short. First of all, let me answer. I raised the issue of evidence from the Amici around conviction rates. The Amici are going to put that report, which has in fact been updated, before the court, which hopefully will assist. I'm told by counsel for the Amici that in fact the stats look worse than they were for 2022, 2023. So successful conviction rates are even lower than they were. But that will be made available to the court and to the parties, of course. On the issue of severance, in relation to Kels's argument, let me say this very briefly. In fact, the discussion that I had earlier with Justice Matopo deals a lot with what Kels's severance argument, which is essentially that you would have to remove the consent requirement from the crime. What that leaves is that it leaves the following. Any person who unlawfully and intentionally commits an act of penetration is guilty of an offense. But if you leave the statute to be drafted like that, then it's possible that all sex is then unlawful. And that can't be right. So you need the intention requirement, you need the consent requirement. I've made the arguments, I don't want to repeat myself, but I think the fact is that if you adopt that kind of a formulation, or what my learned friend for the CAL says is severance, you will result in a situation where you're brought right back to consent, whether you like it or not. It is interesting that CAL's counsel didn't suggest to you what else there was other than consent. And I would submit that's because really there is nothing that I can think of, quite frankly. So we come back to consent anyway. CAL says that our relief, the relief sought by the embrace applicant, places an evidentiary burden on the accused. But I just want to clarify, that's first of all only if the accused raises a defense of consent. It is the same in every other instance where an accused chooses to raise a particular defense. For example, if you raise a defense of self-defense to a charge of murder, you are required to prove that. So it's not an unusual burden, it is not an onerous burden, it is simply that where you choose to raise consent, you must prove it. And still what will remain, in practical terms, is that the accused will raise consent most likely in pleadings, and that the state will then have to adduce evidence to show beyond a reasonable doubt that those factors that show consent are not correct or not present. On the issue of meaningful consent that Justice Theron raised earlier, the effect of including meaningful consent as a requirement in the statute, so reading in meaningful consent, must just be thought about carefully, because the statute itself has in section 1 a definition of consent. So you can't do the interpretational analysis of the provisions alone. You would have to amend the definition in section 1 as well. And when you change that definition, you change the crime itself, because the crime includes consent as it currently stands. So that is why we have chosen to craft our relief in what we consider to be a way that's true to the structure of the statute, and to focus on the defense. And if one does the analysis of simply taking the impugned provisions and crossing out the word without consent in each one of the impugned provisions, one sees very quickly that we'll certainly run into trouble. So I think even simply to read meaningful consent into all of those provisions is not a simple fix. It would require more than just an interpretational analysis. Then on the WLC's arguments. First of all, the WLC were not in the High Court. They intervened as an amicus in this court. I'm not sure that their interventions are strictly as true amici, but I won't say much more about that. I would urge this court to read the Magistrates' Court ruling again, because there have been very sweeping statements made about why that ruling is wrong and what evidence was or was not led in that case. But the transcript, as my learned friend has admitted, is not before her or this court. So no one has had sight of the transcript and knows what was actually led or wasn't led. And so it is dangerous to make sweeping statements about the Magistrates' Court being wrong in this, as if this was an appeal of that decision, when we don't have all of that. The effect of the WLC's argument is effectively to say, is a cautionary one. It's to say, we don't know how this will work, and so don't go there. That's essentially what it is. We heard many, many suppositions and theories and conjecture about what might happen if we import a reasonable steps requirement, as we suggest should be done in the relief we seek. And my learned colleague herself referred to it as dealing with thought experiments. Well, we are not dealing with thought experiments. We are saying to you that there is an unconstitutionality in the statute that's clear, and that unconstitutionality must be fixed, as this court routinely does. And the way to fix it is to declare it unconstitutional and to declare an interim reading in the defense provision. The alternative is to leave, if you adopt the WLC's approach, is to leave in place a system which allows the focus of any court considering a rape charge to be on what was subjectively in the mind of the accused. And it's interesting that the WLC doesn't deal with the example that I gave you about the most conservative patriarchal man who believes that the less progressive a man is, the more likely he is to be acquitted of rape on the current statute, because it's his subjective intent that is the question that the magistrate will have to deal with. They don't deal with that. They ask you to leave that in place because they're not sure how this relief that we seek will be implemented. But we submit that that's not correct. And that in fact what the relief we seek is actually, it requires very little from an accused who seeks to raise the defense of consent. It's not complicated. Consent itself as an ideological concept may be complex, as the Amicus says. We don't dispute that. But the steps that we ask an accused to take in the relief as we formulated are not complicated, as I've been through. The final issue that I'm watching the time, I wanted to be able to respond to you on the Canadian law, which I'd ask my colleague, Mr. Ben Winks, to deal with, if you'll permit me. But before I do that, I wanted to say a couple of things about the minister's argument. The one is that the minister referred us to paragraph 50 of the High Court judgment that doesn't deal with the right to silence, it deals with the reverse onus, just to point that out. So the right to silence is still raised for the first time here. But I understand my colleague's argument that they've abandoned the reverse onus. On the 36 months, I apologize for any misunderstanding. It was not that I agreed that 36 months is all right. I certainly have no instructions for that. But what I do want to say is if there's interim reading if there's interim relief provided, and if at the end of that suspension period the interim relief becomes final, then my clients would be protected. But we do understand that this court routinely have cases coming back to it because the legislature hasn't complied in 12 months. So that is why we've extended to 18 months. If this court thinks 36 months is appropriate, so be it. But I don't have instructions to agree to that. On the costs issue, we continue to see costs. We have done from the beginning along the lines of BioWatch, and there's no suggestion that our litigation has been frivolous or vexatious, and so we will stand by that. Justice Mhlantla, To the extent that the court is concerned about the Canadian position, which the WLC has made extensive argument on, there is a response to that, which shows why that's actually, the concerns raised by WLC are not relevant. Would you permit me to just ask Mr. Winks to address that one question very briefly? Thank you very much, as it pleases the court.
As it pleases the court, thank you, Justice Mhlantla, for the indulgence, especially over time. The Canadian point that we've raised is a relatively straightforward one, which is that the Canadian experience tells us that what was targeted in that jurisdiction and in other jurisdictions is a specific defense that was seen as a constitutional mischief, that was seen as a rights violation. And in R versus Barton, which our learned friend has referred the court to, it's explained precisely why that's a rights violation, that defense. And we commend paragraphs 104 and 105 to the court for an assessment of why exactly that retention of that defense is a rights violation. Now, the Women's Legal Center Trust has argued that Canada is different because they have a jury system and these provisions exist to guide juries, but that's not what criminal codes do, in fact. They may have a jury system, but we have in that jurisdiction, a criminal code is there to tell people how to behave, tell complainants, to tell men, to tell boys how to behave, and what the consequences will be if they misbehave. The fact that it's a jury system doesn't change that. And what we have in our law is a legal position according to Oko, and that's the one thing that all of the parties can agree on, is that Oko was correctly decided. That leaves open what we call the Amos defense, what the English call the Morgan defense, and what the Canadians targeted in 1992 as a constitutional mischief. If that defense still exists in our law, then we say it has to be excised. And the importation of reasonable steps and unintended consequences, firstly, the criticisms were addressed by the Canadian Supreme Court in Barton, but the main point is that if there is nothing, the contradiction that we're battling with on the side of our learned friends is that on the one hand it said that our law already includes an abolition of the Amos defense. That is not a defense in our law because of Dolus eventualis and the reasonably possibly true standard. But then they say, well, if you include that defense, as the embrace applicants ask you to do, then there will be unintended consequences. But if it's already in the law that that defense is abolished, then those consequences would unfold anyway. So I hope that we've answered the difficulties that may have presented. It's obviously a very vexed case, and there are emotive facts that arise from it. But one point we would want to emphasize is that Miss Holtztrager's case is not an isolated incident. And it's no answer to say it was wrongly decided, because then there wouldn't have been these interventions in all of these other jurisdictions to target that very defense and excise it from their law, because expressly it's a rights violation. Is that okay?
Thank you.
Thank you, Justice
I
Mhlantla.
think there's a question for you, for Mr. Rajab Patenda.
Ms. Rajab Budlander, I just wanted to didn't want to become like Donald Trump. Just wanted to ask this.
It's not possible, Justice Rogers.
Feeding in. It becomes, as it were, a standard defense. Yes, I did ask the lady whether she was okay with intercourse, and he said yes. Am I right that then the accused will be entitled to an acquittal if that is reasonably possibly true?
Yes, it will be like any other case where you have two conflicting versions. He will say, I asked her if she consented, and she said yes, and she will say, he did not ask me if I consented, or I said no, and he continued nonetheless. That will be a matter for evidence, and a court will have to make the assessment, as it does in any case where there is conflicting evidence.
And ultimately, although there might be a high probability that that the complainant didn't consent, the accused in that instance will still be entitled to an acquittal. He won't bear any onus.
No, that's correct.
Thank you.
Thank you. Thank you, Justices. Thank you.
Good afternoon again, Justices. I aim to make 3, hopefully simple submissions. The first question the court has to think about is, what does removing consent do to mistaken belief in consent? Removing consent, along with the ACA's clarification that belief of consent is appropriately a subjective test, but includes assessment of objectively ascertainable facts, moves the conversation away from consent being the only consideration. Second question, what will removing consent do to how we understand unlawfulness? It will appropriately place rape in alignment with other assaults and other non-gendered crimes, where the harm or unlawfulness is not just the absence of consent, but it's unlawful because it is violence. It's forced against vulnerable groups in a sexual manner as a result of power imbalances. The unlawfulness stems from the infringement of physical and psychological integrity, not sex. What removing consent does is move away from the complainant needing to show through their testimony that the conduct was not lawful because they did not consent. It moves our understanding of rape as an unlawful conduct for which the accused may raise a defense, consent, compulsion, but without the state having to have a double burden of proving elements of unlawfulness and lack of consent. That, as I've submitted, is tautologous. That isn't just semantics. It has placed an enormous onus on the state and the complainant by centering the entire offense around consent because of the definitional element. In relation to separation of powers and remedies, if this court is persuaded that consent imposes right violations, it can remove consent, as we've suggested, or it could do read in coercive circumstances. The court can decide what it wants to do. Neither of these options violate separation of powers, because the legislature has already included consent in terms of coercive circumstances. It would have been hoped by doing this was sufficient clarity that consent must be understood in this context. But the fact that we are here is clear that greater clarity is needed. In our view, removing consent or shifting away more centrally provides that clarity. CALS's argument and remedy sought is not as radical as it appears at first. It is not substantially changing the definition of rape and any other sexual offenses. In fact, it is bringing them in line with other offenses by appropriately placing consent in the context of unlawfulness. To require consent in sexual offenses and not in other offenses is to misunderstand the nature of sexual offenses and to continue that discrimination against victims of sexual offenses. Embrace, on the other hand, requires a remedy that will depart from the standard of mens rea, a matter we believe that is best left for the legislature, because to grant that would be a violation of separation of powers. The embrace remedy also adds an evidentiary burden, and yes, my learned friend, Raja Butlander said, it only happens when the accused decides to testify. What we as CALS are trying to do is the complainant will be the first in the witness box because the state has to prove its case. And when the complainant is in the witness box, it has to prove lack of consent. So the problem for the victims is the undue burden then. There is no clear evidence that the request from embrace will significantly change that outcome. In fact, it may further create a lack of clarity in the law in relation to the standard of fault and the difference in how sexual offense accused and all other accused would have access to the common law defense of mistaken belief. In sum, removing consent will place the appropriate and relevant consideration front and centered, the violation of bodily and psychological integrity. Thank you.
Thank you to all counsel for the engagement in this complex matter. Judgment is received. Court adjourns.